All right, I'd like to call this meeting to order of the Tennessee Auctioneer Commission. You want to do the roll call, Don?
Yes, sir. Marvin Alexander.
Here.
Bobby Colson.
Here.
Gary Cunningham. Jeff Morris.
Here.
Howard Phillips.
Here.
You have a quorum, Mr. Chairman.
All right. And I'd like to review the agenda and see if there are any. Now, is that on our pad here?
It's on your tab.
That is your agenda.
Oh, this is the agenda. Okay. I'm not used to looking at paper anymore.
Chairman,
All right. Yes.
I would like to leave it at your discretion, Commission's discretion, to move tab 7 up. I wasn't sure that Mr. Smith was going to be here today, or whether he was going to be able to attend, so I put it on the agenda down a little lower in the meeting, but he is here if you want to move that up, although he says he's in no hurry. But that's a possibility if you want to move that around.
I have no problem with it at all. Board,
Yeah, we
agree with that? All right.
We need to go ahead and adopt it.
Let's move that up to right after the reading of the minutes, and then when we adopt the agenda, we'll have it on there. All right.
I move we adopt the agenda with that change.
Have a motion to adopt the agenda. We'll have a second.
Second.
Second by Marvin. Or Commissioner Phillips, take your pick. All in favor? Aye. Agenda is adopted. All right, has everyone had a chance to look at the minutes from the last meeting?
I have.
Haven't?
I have. Yes, sir.
I haven't. I haven't. Do I hear a motion to approve the minutes?
I make a motion to approve the minutes.
Second.
Motion by Commissioner Phillips, seconded by Commissioner Morris. All in favor?
Aye.
All opposed? I don't know if I should have signed that since I wasn't here, but there you go.
Yeah, that's all right.
All right. I guess we will now go to tab 7.
Mr. Smith.
Mr. Smith.
I'll just give you a little background on why Mr. Smith's here. We had a telephone conversation, and he asked some questions that I told him I would have to bring to you to answer. He was a licensed apprentice from 1988 to 1989. And you'll see that license there on page 3 of your under tab 7. He applied to upgrade that license in 1991, but he didn't quite follow through with the process. He does have the 30-hour course. He had that in 1991, and he's here today to ask that you waive the apprentice logs for him to upgrade his license. And I will let him tell you why.
Yes,
Mr. Smith.
introduce myself to couple.
That's Bobby Colson.
Smith, sir.
And that's me too.
I think I met everybody now. I don't know how y'all are familiar, how far y'all go back in the auction business. My father was Colonel Don Smith, and we lived in Memphis, and I still live in Memphis. And he started Delta Auction Company, sold it in 1968, and then had various forms of his own auction company. There was Don B. Smith and Herman Smith, and he would get different parties at various times. I've worked for my father off and on since I was 10 years old. My first time I worked in auction, I run ring tickets in the auction off Union Station in Memphis. He also, of course, I was a kid, I didn't even get much, but at that conversation at that time. But as far as he goes, he was the premier auctioneer in the state at the time, at least that part of the state for many years after that. He auctioned off Hotel Peabody, auctioned off Hotel Claridge. I've got some brochures and stuff from here if y'all like to see it. And I worked for him off and on for 20 years now. The reason I haven't worked in auction business of late, I went to auction school in '87. Up until that time, I worked my father off and on, going through school and such, and I've done everything. And I know the apprentice log is important, to show that you prove that you've worked auction, how to work auctions. I looked at that log and such. I've done everything on that log several times over. I have proof right here. I mean, I've got a picture of me from the paperwork and the ring at an auction. I've got my father auctioned off James Earl Ray's Mustang back in 1987. I have brochures and such from that. I know how to. I've called bids. I worked ring. I wrote up advertisements. I wrote up contracts. I wrote up newspaper articles. I wrote up. I've moved. I've done the labor part of the auctions. I've moved furniture in. I've tagged inventory, tagged furniture, and such. And I've pretty much done everything. I've checked out a clerk. Anything to do with the sale, I know how to do. My father was a good teacher, and he taught me good. He got sick in the late 90s, got lung cancer, lifetime smoker, and he died in May of 1998. So pretty much before that time, though, he lived in Alabama for like 10 years, and I didn't auction, I didn't call bids because I didn't have a license in there, obviously, but I did help him out. He had a company named Auction Masters in Alabama for 10 years. He had a sister down there and some nieces that would help him. So I helped him. I went down there and I helped him. I have an uncle that lives in Cookville, Tennessee, named Paul Glenn Smith. He had Empire Auction Company. He's retired, and I helped him off and on. And I've been to various parts of the country. I went to my father in 1980. We went to California, auctioned off some of Elvis Presley's furnishings from his house in Beverly Hills. I was at that sale along with 3 of my brothers. And he had lived for a while when he was in Memphis. He lived in Covington. He was married several times. He lived in Covington. He had like an assignment barn. I helped him with a lot of sales out there. And all I'm asking him, and I understand the 2-year log deal that you're supposed to keep up with, but I feel that I've already, I've got the evidence here. You're going to see it. I've already done that. What I would like to do, I would like to apply for, with your approval, I'd like to apply for the Maine Auctioneer's license, test for it, and apply and test for it, pass that. My fiance is a art and antique appraiser. She's a certified court witness. She and I are interested in starting a business together. I've got some feelers out in Memphis for some storage auctions I would like to start getting involved with. People that, in other kinds of storage. I worked at Farley Express for 20 years and I've retired, and I'm just looking for, I got retirement, obviously it's not as much as I'd like it to be. But what I would like to do, at the same time I'm taking care of my mother, so I'm trying to do something that will give me some flexibility to work for myself, work with my fiance, and work with her and others that I can see, and just get something going. In today's economy, it's kind of tough, and the way I pretty much figured it out, as most of you all already know, the only way you're going to make any money, though it's a risky business, the only way you're really going to be able to rely on something is rely on yourself. Though I've had different kinds of jobs, I'm 55 years old now. Auctioning is something I've pretty much grown up with since early age, and it's something it's never been the most reliable kind of job, insurance and such like that, but it's an occupation I've always enjoyed. I enjoyed the camaraderie of other auctioneers, camaraderie of the people, different buyers and sellers and such, and I've just enjoyed the whole process. And that's all I'm asking is just, if possible, just to bypass this so I can only take my regular exam. If y'all want to see any of this stuff, then I have it right here. See it.
You have your apprentice license is up. When I say up,
It's expired.
update, it's expired.
Yes,
Your
sir.
apprentice, when did your apprentice license expire? 89?
1989 or 90, something like that. Like I say, just have to remember, even though I started working at Federal Express in May of 1990, and so pretty much around that time, my father moved to Alabama in about, I think, 89 or 90, somewhere around there. I think it's 1990. He moved to Alabama, so obviously I couldn't trips back and forth to Alabama. And that's where he started his other company, Auction Master. You know, I did go down there several occasions to help him on sales, help set up and call when I called him, work ring and stuff. But I worked for him off and on. But my main source, my main job, main job for almost 20 years was working at Federal Express in Memphis. So that's the reason, the main reason that I didn't renew the license at the time. Because after he moved, I figured, what's the point? I still work for him off and on. But my main job was working at Federal Express.
Did you ever have an auctioneer license?
A regular auctioneer's license?
Yes, sir.
No, sir. Just an apprentice license.
And you haven't had an apprentice license since 1989?
No, sir. No, sir. And I understand that it looks a little dated, and like I say, but it dates me myself. But the whole purpose of it, if I'm not mistaken, the whole purpose of the apprentice license is so under the guidance of another auctioneer, is so you will learn the business. Learn how to do all the things that you need to do. Work auctions, call bids, work ring, inventory, catalog, such. I'm not asking for any special treatment per se. I see it, at my age, 55, I think it's just sort of redundant to ask me to start all the way back over again. I understand when I was 20-something. I'm 55 years old. If I have to serve under somebody else, it's another 2 years. By the time I get something going, I'm going to be 60 years old. Like that, I already know how to do everything. I looked at like I said, I know how to do everything that's on there. Everything that's on there. All I'm asking for is just bypass the law, go on and apply for, and take the licensing exam. I pass that, then go with that, and then down the line, somewhere down the line, I like to have my own firm.
Go ahead, Mark.
When did the law change that you had to go from 1 year to 2 years apprenticeship?
It was 2 years when I interrupted. It was 2 years when I
Was it?
when I did it. Yes, sir.
It was in the 80s.
There's an exemption in 62-19-111, and I'm not saying this is the date, but it might be it. It says, notwithstanding subdivision B2, any individual who would otherwise qualify for the auctioneer's examination by January 1st, 1984, need complete only 1 year of apprenticeship in order to be eligible for the examination. So I would assume January 1st, 1984 would have been when it changed based on that information.
My question for council, do we even have the authority to do what he's asking?
Well,
I was looking in the rules to see if we...
On that you just read, that's very true because it was the law, but in order to get your auctioneer license to take the exam, you had to have your apprentice license up to date to be able to take that exam. And you couldn't let it expire and then take that exam.
See, that's what I'm afraid of on this deal, and that's where we need your advice, Julie, I guess, is if your license having been expired, our hands may be tied.
So I understand. Like I say, I'm not asking for things
Maybe
outside.
nothing we can do.
I can understand. I'm just saying that. I'm just saying that.
And that kind of where you were going.
Yeah, I don't know. I'm trying to figure out if we even have the right to do that.
I'm just saying that to me, it's just redundant to have to go through the whole apprenticeship again.
Well, I don't disagree with you.
When I'm not going to learn anything, I'm not saying I won't learn anything new. You can always learn something new. But I'm just saying that as far as like the basics of it all, I know how to do all of it.
We get that, and we understand where you are.
I understand
We're just trying to figure out whether we have any leeway on this thing at all or not.
Like I say, I expected that. You know, decide how you decide. Just asking.
Rule 0160-01-.22, which is late renewal of license, that's somewhat this is a renewal and an upgrade, but it says a licensee delinquent in the renewal of a license for 2 years or more shall reapply for licensure and shall satisfy all requirements for obtaining such license. Under your charts tab in your books, there is a chart that's prepared based on the statute and the rule, and the requirement is to retest proof of a 2-year apprenticeship, proof original 80-hour education course, 30 hours additional classroom instruction. Based on the information we have here, it looks like Mr. Smith's license was issued on January 29th, 1988, and it expired June 30th, 1989. That's a period of about 1 year and 5 months. That's not 2 years.
I think it's fine. I mean, if it's made out for 2 years, like I say, I don't remember stuff from way back.
I mean, this is 89 and this is 2012, which looks like mission expired for
22 years.
Well, I mean,
a quarter century.
I mean, that's fine. I mean, I understand, like I said, within that time frame, I've done a lot of stuff. I worked a whole career within that time. I still, helped out with following auctions and stuff like that. But at the same time, I went to auction school. I've already gone back. I've taken the 30-hour continuing education course. I took that, and I think I took that. And I know there's a new, I don't know how new it is. I was reading up online last night. But there's a new 6-hour course or something. I don't know that much about that. But I'm more than willing to take that.
Well, I think the board's sympathetic to your cause. I just don't think we have the authority to do what you're asking. That's my concern.
I don't think.
I mean, by statute, we don't have that authority.
I understand that, but you said just a retest. Excuse me. You said it's like just a retest. I'm about to retest the same apprentice test that I took before.
That's what the law says.
You have, it looks like here, based on our records, that your license was issued 1/29/88, and the copy of the license that you gave us says it expires June 30th, 1989. That's approximately 1 year and 5 months. There would have to be some kind of proof that you had that 2-year apprenticeship, and it looks like that's about 7 months short.
Well, let me ask you something. When you all, I'll just go back then. When you all issued a apprentice license, is it not automatically for 2 years?
Our used to, our license, it expired on June 1 or June 30th.
This one appears to have expired June 30th.
And I think what you did, you just, wherever you went in, the way I remember it, and I could be wrong, you started at whatever segment you were in the 2-year review.
pay your pro rata share of it.
Yeah.
Okay, well,
Back in.
my mistake.
I mean, I may be wrong.
That's my mistake.
Yeah, I think you're right.
I understand.
But I don't see where in the statute or rules it gives you all the authority to waive those requirements of licensure.
Here's my question on this. Now, you said without me showing adequate proof that that I was an apprentice or something. I have as much as I can have right here, as far as I've got articles that I've written. I've got pictures of me working ring. I've got advertisements, such like that.
We appreciate that, Don. The problem is, the license has been expired for so long that we have to be careful about setting precedents.
I mean, if it had happened 1.5 years ago, we would
Like I
have
said,
some
this is just
leeway.
something,
But
since
I
I've
just
been
don't think
retired,
that-
this is just something I wanted to get back in. I thought,
We perfectly understand your situation. I just don't think we have the
I
authority
just
to do
don't
what
think we
you're
have
asking.
any leeway to do it
okay, so.
legally.
You said there wasn't really anything to do, but now, if you go get your apprentice license and get you a good sponsoring auctioneer, you can still do your deal.
But I can't do anything without the sponsored auctioneer being present. Am I not correct on that?
That's right.
Yes, an auctioneer being present, yes, sir.
It looks like from here, you have documents showing that you were licensed for 1 year and 5 months. There would just be that 7-month balance, not the entire.
What else? What do you want me to show?
My question though, Julie, is even if we had the law, it's still been expired for 22 years. I don't think we have any authority to do it.
It's start over.
How long can a license be expired
2 years.
without you having to take this?
I mean, I think we got a whole lot bigger issues than just the law.
I mean,
I mean, don't-
2 years.
you got- I mean,
I'll let my
I agree.
license
I'll
expire
go
for
whatever
2
you
years,
guys
and I
say.
gotta start
I mean,
all over
different
again.
You go,
This has been 22 years.
right. Right. If it's been over 2 years, you go to that chart over here, you have to satisfy all of those things. But it says proof of 2-year apprenticeship. So,
The only proof of apprenticeship, and I understand what the law, is the only proof that you are willing to accept is a law that is signed by, the sponsor auctioneer. I mean, I understand you have your rules and regulations, but what's
Yeah,
proof?
but yes, but I think we got a whole lot bigger issues than just the law book.
Okay.
Is
Got an expired license.
I want to ask council a question. If my license expired December the 3rd, 2012, and I don't renew them or don't try to renew them until 2016, do I not have to go back and complete the courses again?
Yeah, you got to start all over.
We have been accepting proof, as she said, that you completed the apprenticeship program, that you had the laws, that you did the 30 hours.
when it's been over 2 years.
Yes.
Yeah, we hadn't required anybody to go back and take the 80 hours.
We'll go through another 2-year apprentice program.
We waived it, as long as they're licensed,
If a license has been expired over 2 years.
They had to start over, is what it
license
said in the previous
expired
program.
Right.
because he didn't have a bond, and he had to go back and take the apprentice license,
Right.
serve for 2 years, and then get his auctioneer license.
Yeah, that's what the law says.
And that was my son. I know that happened.
Yeah, I agree with you on that.
Yeah, that's exactly what's
So I don't see
that's what's
that-
supposed to happen.
And I'd like to, I want to see everybody get their auctioneer license.
Yes,
But
sir.
my personal opinion is, I don't think you can do it under these circumstances, and I would have to vote against it.
Yes, sir. I understand.
I said, I just think our hands are tied. I really do.
That's true.
So, more or less what you're saying is I have to apply for an apprentice license again, take that exam again.
I think so.
That's what the law says.
That's a definite on that, okay? All right. All right, guys, well, I very much appreciate your time. You gotta have a motion.
Yeah, that's,
Howard, you want to make a motion?
I make a motion that we reject, is the right, correct word, reject the applicant's deny the request.
you hear a second?
I'll second.
And Mr. Smith doesn't make me feel good to do that, but
Well, I understand. You guys are just doing
Second
your
by,
job. Doing your job, keeping
all in favor? Aye.
uh,
Would like to note that Commissioner Cunningham's came in. Good to see you, Gary.
Good morning, Gary.
Russell?
I have a
Oh, okay. Russell, come on up, son.
Okay, I just have a question concerning this. What kind of exceptions have we made to people's license expiring? We need a rule that is the same every time.
I don't know of any exceptions that have been made. I'll do that. I'll do that. No
Thank you, guys, I
problem.
appreciate it very much.
Nice to meet you, sir.
I understand, nice to meet all of you. Thank you, sir. You guys have a good day, okay?
Thank you.
Appreciate it.
We've got the
I think
late,
we've got 1 hour
yeah,
in that jar.
we've got the late renewal. There was a discussion, and Donna kind of looked at these charts a couple of years ago, because it said you have to reapply, and that's not defined, and that's when she drafted those charts that were voted on by the commission, that's what they determined reapply meant.
Okay, I wasn't here, so I'm just trying to get my mind straight.
So basically, if it's an expired auctioneer, and then it expired 2 years, we're requiring 30 a 30-hour course and re-exam. If it's an expired apprentice, we've been requiring the 80 hours and the exam. If it's
So an auctioneer is expired for more than
2 years.
2 years, so you got a whole 2 years. Then you just take 30 hours and you're back
And the test.
and the test. Okay. All right, that's fine.
But now if it was an auctioneer who'd been expired, regardless of when they expired, if they had served their 2 years, we'd have been allowing them to come in and apply for an auctioneer license with the 30 hours in the exam,
If-
regardless of when it was they.
If an apprentice goes, gets his license and serves an apprenticeship for 2 years and doesn't renew his license for 5 years, he can come in and we grant him.
We give them that apprenticeship and then we make them take 30 hours to upgrade and the exam.
I don't think that's what the law
I don't
is.
think we've done that for anybody
Yeah.
over 2 years.
I'll say.
For an apprentice, because we don't have anything that says their apprentice license has to be current. We just have to show that they had apprenticed for 2 years. And apparently that's what restitution.
Left to.
Well, actually, I have appeared before this commission on numerous occasions, starting in 2002, asking for clarification on that specific issue. And there was a situation when we were way back when we were over at the other building where there was some inconsistencies. And this is one of the questions that we cannot answer at the school when people ask us the question. We just say this is what the standing position is right now with the commission, because a student who had let his license lapse, we had two at the same time, one student who had let his license lapse for 7 years, just took the 30-hour, made application, and was granted an auctioneer's license. Another student who had let his license lapse for 5 years, or his apprentice license, it just expired and they never renewed, never took CE, never did anything. For 5 years, took 6 hours of continuing education, renewed their apprentice license, and then got their apprentice license reinstated so that they could take the 30-hour and advance to an auctioneer's license. And in that particular situation, I know that the state actually refunded that person their license money, and we had to refund their continuing education money because there was 2 people at the same time with inconsistent practice. Our position has always been, we don't particularly care what the decision is, we just want consistency. So when someone calls us and says, well, my apprentice license expired in 2000 and I want to be an auctioneer now, we can tell them what education they need to obtain, but we can't answer that question definitively because this commission has been back and forth on that. Now, for the last several years since y'all did that chart, there has been consistency in that 2-year period of time is the magic numbers, so to speak.
You put that chart in the newsletter.
Put the chart in the newsletter, and I have it up at my desk, and when someone calls, I read the chart for them. So,
Is this a rule or a law? Or is it neither?
it's neither. It's how that law is interpreted, and I think that what the last interpretation, which was several years ago, and so correct me if I'm wrong, Donna, was that because it does not say, the law specifically does not say, like Susan just said, that you have to have a license in good standing to advance to an auctioneer's license. It just says you have to meet that 2-year requirement. If they can produce the log and they have met that 2-year license requirement, then it falls in that gap of not being clear.
Mr. Chairman, I would strongly recommend that this be looked into and some reached other than what we got now. One can do this and one can do that.
No, that's not what we've got now. She said we're being consistent since the chart was put in place. And so there hasn't been any question with her students. She's using the chart, we're using the chart. And this board adopted that chart. I've got the date on the chart that it was adopted.
I stand to be corrected. I thought we didn't have something consistent because we had 2 people apply.
Oh, that was when we were up in the other building.
Okay.
Yeah, that was, what, 8
Sorry.
years ago or so. That was just
I won't be clear.
a historic thing in the computer.
I withdraw.
Well, one of the problems of this, and nobody over here in this room was here at that time, there was license went out of this commission we didn't know anything about, and renewals went out. They did that. That got variances that we wouldn't have approved.
Well, there were a lot of inconsistencies when I came on board, and that's why I wanted to get the chart and give you all to agree to this is what we can do from here on out, and not be doing this for one person and that for another person, and bringing so many. Remember all those applicants we would bring in here before you? I mean, there would be 10 or 12 on the agenda asking for
Right,
something.
every time.
Every time. But now, they're all going by this chart, and it's worked so far.
But now does the chart,
It was approved by council at the time.
I know, but does it, and I like the chart, I love the chart. But does it include apprentices and auctioneers, or is it just testing for the auctioneer license?
Both.
Okay, that's good enough. That's what I thought. That's what my,
And the question with the
Understand.
gentleman that came in was the fact that if there's any variance from this that you guys have approved in the past, from our perspective, okay, they have that log.
Right.
If they don't have that log, then it's like, okay, it goes before the board for you to consider. He didn't have the log, and he sent in the copy of his license, and if you look at the copy of his license, it looked like he'd had it for 2 years, but
well, when I first saw it, that's what
yeah.
I thought.
But when we found the old card file before we went to computers, when she was getting everything together to prepare for this meeting, we found.
Yeah, and we weren't sure, like Commissioner Alexander said, what the license period was good for. And then somebody in the office thought they all expired June the 30th of each year back then. And so he was 7 months short of having proof that he'd done the 2 years.
All right, well, let's move along. Wrestling, you got an auction school report? Seminars and newsletter?
Seminars, newsletter, it's newsletter time, and the last
Oh, boy.
two, I know. The last,
Everyone's read the letter.
we don't even need to say anything else, do we? The last 2 newsletters, we have not had a letter from the chairman, and I very, very much need a letter from the chairman this week. So we can, because we have the Christmas holidays coming up, we can work around it. Or, Commissioner Colson, just to let you off the hook a little bit, if any of the other commissioners would
No,
like to step
be
up
happy to have a
before
ghostwriter
they-
if anybody's got anything.
write a letter that haven't had the opportunity, we would be more than happy to put that in instead. So that is my report. We have February 18th as a pretty firm date, and that will be firmed up for the newsletter for the winter seminar at Natchez Trace State Park. And we just had one of our speakers confirm late last week, so we're just making sure that everything's just right with the park and we'll go forward. And that's on Monday.
Hey, Bobby, just a suggestion, you might talk about what we just talked about. And what we're about to talk about is a couple of topics in this meeting that would be very timely
For the,
for the newsletter.
We have
And stress the fact that the commission is trying to be consistent on all decisions, so that there is, it's fair for everybody.
And we have put that chart in before, but it's never a bad thing to put it in again. We can
Well, you don't have to
put it
include
again
the chart,
and
but you can just say,
remind.
look, the commission's striving to, be consistent in its practices and, fair across the board for everybody. And then we've got another topic coming up that you might want to, there's a couple of things here that are kind of timely and that are in the marketplace right now that you might want to just kind of stress.
Absolute auction.
Yep.
That's a discussion.
That's a discussion. Okay.
all right,
Good. Thank you very much.
thank you.
Okay. The first three matters are 2012-011-211,
We're on the legal report.
This is
Says legal report, guys.
I'm sorry, I don't think it says that. I think
It just says legal report. See that maroon folder.
got it.
I gotta get back to that page.
Kind of poke it at the bottom.
What'd you do this thing?
Just keep turning.
Let me show you a little trick. Sit up there for you all by itself.
y'all ready?
Okay, I think we're ready.
Okay. 2012-011-211, 2012-012-401, and 2012-012-402. This was originally presented at the August 2012 meeting. This was a TAC opened complaint based on a copy of a newspaper advertisement received, which advertises an auction of antiques, furniture, home decor, etc., which lists the name of an unlicensed entity, Respondent 1. Based on the information in the newspaper advertisement referencing an auction zip ad which contained the license number of Respondent 2, an auctioneer, and the name of Respondent 3, an auction firm, complaints were opened against these respondents. Respondents was received stating that Respondent 3 was unaware that Respondent 1, a separate business, needed a separate license since Respondent 1 was mostly auctioning its own property. Respondent 3 states that Respondent 1 has ceased any consignment auctions until the complaint is resolved and they are instructed on how to comply. Regarding the newspaper advertisement's lack of including the firm name and license number of Respondent 3, Respondent 3 states this was an inadvertent error on the part of the newspaper which has been addressed, and a letter from the newspaper was included confirming this. A telephone call with the owner of Respondent 3 firm confirmed that number 1 is a separate business owned by one of Respondent 3's apprentice auctioneers. The apprentice has closed Respondent 1 business and plans to obtain a gallery license before engaging in activity of this kind in the future. The recommendation at that time was as to Respondent 1 a letter of warning regarding Tennessee Code Annotated Section 62-19-125's gallery license requirement, as to Respondents 2 and 3 a letter of warning regarding Rule 0160-01-.20 subsection 1's requirement that auction advertisements must contain the name and license number of an auction firm or gallery responsible for holding the sale. At that time, the Commission voted to defer this matter to send it out for investigation to determine how many auctions Respondent 1 did and whether Respondent 3 properly sponsored all auctions. An investigator was sent to obtain additional information regarding this matter. The investigator's report indicates that the investigator spoke with and obtained an affidavit from the owner of Respondent 3 firm, who stated that an apprentice auctioneer with the firm owned Respondent 1. The owner stated that Respondent 1 held approximately 8 auctions consisting of household goods, furniture, and antiques. Respondent 2, the principal auctioneer for Respondent, that's supposed to say Respondent 3 firm, was present and supervised at all auctions. Further, the owner of Respondent 3 states that Respondent 1 has held no additional auctions after being notified of this complaint. The investigator also interviewed the apprentice owner of Respondent 1 and requested copies of listings of items sold, bid sheets, and invoices from 8 auctions held by Respondent 1. According to the investigator, the apprentice owner of Respondent 1 promised to provide copies of the documents which were in storage. The investigator made multiple unsuccessful attempts to obtain the documentation. The new recommendation is to discuss based on the fact that this information was obtained at the request of you all.
They haven't obtained any information yet. Looks like you'd be asking for the information and they had never come forth with it.
Well, y'all's question was how many auctions were there and to confirm that the person had been supervised. That's all the investigator was able to obtain. At least it did answer some questions, but like I said, the report indicated that the investigator had tried to get the documents multiple times and was unable to.
It sort of concerns me that the investigators asking for documentation and then they didn't stonewall.
Do you know if that's a common problem, Mark? I haven't sent out enough of these to know.
I mean, no, it's not. Unfortunately, it isn't. These documents aren't on. It's not operating area here.
You may be the one missing mine.
That's a good possibility.
No, they hadn't been downloaded to their iPad yet.
Okay. So,
I don't know what there is to discuss other than we're not really any further along with information.
Well,
They had
if-
8
if-
auctions that been given instead of 1, you know.
If he's not gonna provide that information, I think we ought to have a hearing and rescind his license.
The number right now, number 1 is opened in the name of the unlicensed entity. There's not a complaint open specifically against that auctioneer. However, we do have an affidavit from the owner of the firm that apprentice is with, stating that he is the owner. So I guess that could be covered in the
I
same
make a
hearing.
motion that we
Mark,
open
right?
a complaint against both of them. It either be set for a hearing or they take care of it.
I'll second that. I think that they should be sitting down there explaining.
So you'd like to open a complaint against the apprentice that owns the unlicensed firm?
And then the company, whoever sponsored him. I mean, when you sign on apprentice, you're responsible for him.
Absolutely.
Right now, this is open. Respondent 1 is the unlicensed entity. Respondent 2 is the apprentice's sponsor, and Respondent 3 is the firm that the apprentice is licensed with. So there may not be a need, based on what I'm understanding what you're saying, to close it.
Well, one of these people, the way I understand what you're saying, is an apprentice auctioneer.
The owner of Respondent 1, which is an unlicensed entity. It's opened in the name of the unlicensed entity, like ABC Auction, which doesn't have a license. That's
and
who
the one that owns that is the apprentice,
is,
right?
yes, he's not directly got a license open. I mean, he doesn't directly have a complaint open against him, but the name of his unlicensed company
the
does have a
the
complaint.
apprentice, who is his? I don't know his name. The apprentice has to have a sponsor.
He does, and that is Respondent 2 here. There's a complaint already open, so I don't know that we need to reopen it based on what I'm
Well, if they're not
understanding.
going to do nothing, let's say it for a hearing.
What they're saying is that he's not producing the documents the investigator asked for.
Okay.
So
Consent order for, or,
we have to get to the point first where we have to notify them of this is what we believe you're in violation of, and in order to, and we're approving this, authorizing this for a formal hearing.
Of course, he
Or a
stated
consent order for X amount for violation that we believe you committed. So we got to go through that process of
Well, let me ask you this. So the complaint is that the apprentice auctioneer was holding auctions without being licensed? Is that what we're saying?
the complaint is, number 1 is the unlicensed entity, and so the recommendation originally was a letter.
Let's
sorry.
get back to what is the violation that we're looking at?
Operating an unlicensed gallery.
All right, so he's operating an unlicensed gallery as an apprentice auctioneer under a supervising auctioneer.
Yes, or he was at one point, yes.
Okay. So he had more than one occasion, he had these auctions, at least on 8 occasions that they've admitted to.
That's what the owner of it states.
Right, and so he, and all of them as an unlicensed gallery with an apprentice auctioneer, with a supervising auctioneer. Well, I think what Marvin is saying is the supervising auctioneer, his responsibility is to make sure that that apprentice auctioneer is acting lawfully, and that we should hold the apprentice auctioneer and the supervising auctioneer accountable for that.
and he's included in the complaint, right?
And he's responded to.
The supervisor.
Am I saying that
The
right, Mark?
supervising is number
Yeah,
2.
but you know, when I said it, or the way Julie, I understand, said, no, he's unlicensed, you know, so.
The actual
The gallery is
respondent-
unlicensed.
The actual respondent is the unlicensed gallery. The
Right.
apprentice is not one of the, I know you don't have the names in front of you, and
Right,
that's what
right,
makes
right,
it
right.
confusing. The apprentice is not one of these named people. It's not who is on the
No,
complaint
ABC
document.
auction
Is who's on it.
is had a complaint against it. Sam, who owns ABC Auction, is not been fined. And Bob, who's Sam's supervisor,
He is respondent number
is
2.
number 2. So
But
I'm saying,
I think what
I
you
don't-
was saying is it's already open against all three of them, so we don't.
no,
right?
if there is no complaint against the Apprentice Auctioneer.
There's not one open against the Apprentice Auctioneer because based
Okay.
when within the
Sam
time.
and
It's against ABC.
It's against ABC and Bob.
Which doesn't exist.
I'm just saying,
Is the Apprentice Auctioneer the owner of the, is the gallery owner?
yeah. he owns it.
According to the information we have, yes.
So he's operating an unlicensed gallery.
That's right.
Well, I don't think,
That's what I thought it was the first time this come up.
I don't think we need much discussion about an unlicensed business operating. I think we need action.
And there is a complaint open against the unlicensed gallery, which is owned by the unlicensed apprentice.
Correct. 1 is the unlicensed gallery, 2 is the sponsor, 3 is the firm where the sponsor and the apprentice hold their license.
Somebody
I think we
owns,
need 4 of the apprentice.
somebody owns the unlicensed gallery.
The apprentice.
Right.
Is your motion still on the floor?
Well, I just want everybody that's in, I'm gonna be sure that apprentice is here.
It's included, right?
Yeah.
The apprentice should be included.
You said 3, right?
I thought whenever I.
Well, here,
I mean,
whenever it was
do you have the
said,
authority, do we have the authority to ask them to come before this commission to explain what's going on?
Yes, sir.
Well, I mean, you have the authority to have a hearing, and, I mean, you can,
I make a motion, we send them a consent fine equal to what we fined that man for dumpster diving. So many $1,000 a sale. That's what I make for 8 times that. What do we fine him, $1,000 a sale or 2?
Is that from the formal hearing earlier this year?
I don't,
Is that the one
we
you're
did
talking
this,
about?
we sent a consent fine out for this, then we sent a formal, that'll get their attention.
there's a license gallery.
If we send them a fine, and then they can appeal the fine.
Well, it'll just be a consent fine, they're not gonna pay it.
Has he applied for a gallery license?
No, I don't think they want to do it anymore.
They quit.
No, I thought they said they were gonna apply for one. We won't quit until they got their gallery license.
Oh, we got caught. We better stop back up here.
We better stop here.
Reprogram this.
A couple of days before the meeting, Julie gets on, they have her RBS, our system, and there would have been a note under that license information on your report that this has applied. So,
Well, yeah, I mean,
Mark, what would be your recommendation for us to get to the bottom of what's going on? Send them a fine and have them appeal it, or what?
what's the law? Give me just a second, Commissioner Allen.
All right.
I don't think they need to come down here. Explain themselves.
Marvin just been saying they quit, that the sponsor was there supervising. Not getting them.
Yeah,
Well, tell them somebody can't get your records from your license.
Right.
He's a mark.
Well, some people are almost skipping the apprentice program. And it's strictly
Yeah, that's what they're trying to do.
through the gallery license.
That's exactly.
They come and take the test, they get somebody to sponsor them as apprentice. They come right back and get them a gallery license themselves, and they start operating on their own, and the other guy's never involved. That's been going on ever since the gallery license was made.
That was bad.
I can argue that. I mean, you have to have a gallery license, yes. So,
We need to, we've got too many things not on the record here, too many conversations, can we?
I'm sorry, we're trying to figure out how to, I guess, administratively make it work.
the civil penalties under the rules for gallery licensing. Under 102A, the license requirement, there's the authority to, under that TCA section, to assess the civil penalty. Solely under the gallery license, 125, in the rules of the Auctioneer Commission, there's not a specific definition of not having a gallery license having the authority to assess a civil penalty under that. And so Julie and I are discussing the authority the commission has under this. We have 2 licensees running an unlicensed gallery.
We have 3. Two licenses. Yeah.
Right. And then
3 entities.
3 entities.
Right, I agree.
So the question is, what is the maximum penalty in the issue?
Well, I think, I mean, under 102, I think the maximum penalty is 1,000
Times 8 or times 9?
times for each sale.
Is that for the apprentice licensee or is that for the gallery license?
That is for the gallery license. That's for the entity.
For the unlicensed activity.
The unlicensed activity.
What about the person who was committing the unlicensed activity?
There's not a complaint open against the individual apprentice at this time.
Well, that's what I understood you to say a while ago, and then I know you say it was. So I'm really confused now.
No, it's,
There's one open against the unlicensed gallery, the name. There's one open against the individual who is the sponsor for the apprentice. And there is one open against the licensed firm where the sponsor and the apprentice rightfully hold their license. There is not a complaint against the individual apprentice who owns the unlicensed gallery.
but his sponsor is, so the sponsor's supposed to be watching him anyways.
There's one against the sponsor and one against the unlicensed gallery, but there is not a complaint opened against the individual apprentice because at the time we got the information, we didn't know
Right.
who was the owner. And so I'm trying to figure out how we need to, if you all want to discipline that apprentice, we can't just create a complaint at this point. I think we would have to open a complaint. Am I right, Donna and Susan? Against, if they wanted to discipline the individual apprentice, we would have to open a complaint against that individual, since we do not have one at this time.
But don't you think it's appropriate to punish the person who's operating without a license?
That is the apprentice.
Yeah.
Look, under
Complaint over to him.
Under 112, I mean, I think under the umbrella of 112A, 112B, the commission may suspend, revoke, refuse, or renew any license issued under this chapter. I think under the provisions of that, B, violating any provision of this chapter or any rule or regulation duly promulgated under this chapter. Right. Yeah, I think under that you can assess against the individual, a licensee from owning
An
unlicensed.
Could you revoke his license?
Yeah, under that. Right, yeah, you have to go through the process. You have to
I
notify
understand that.
all that. But yeah, under that and under section 12, any conduct of any auctioneer that demonstrates improper, fraudulent, incompetent, or dishonest dealings, I think that covers.
But if I sponsor an apprentice,
I make a motion we open a complaint against the apprentice also.
Well, I would recommend that you hold the other two. I mean, you could.
We already have a complaint against them, right? The other two.
Right. Do you all want to pursue any action against the licensed firm where the sponsor and the apprentice hold their license, or just the two individuals and the unlicensed entity? Because
I tell
right,
you,
I think we need to get them all.
that's what I want to breing this thing to a head.
Well, in order to do that,
We've
we've
been
got
going
to
for 3 months.
have a motion to open an investigation to the apprentice who has not been investigated, correct?
Or complain against
A
them.
complaint.
Well, yeah, there's no formal complaint against him.
Well, I still have my motion that we,
All right, we have a motion on the floor to open a complaint against
apprentice
the
officer.
apprentice.
I would like-
Can we get it on in one motion?
Yeah, I'd like to amend that motion
Okay,
to say that we include the apprentice auctioneer, the apprentice sponsoring auctioneer, the unlicensed gallery, and the firm of the sponsoring auctioneer. If I haven't, if we get a second, then I'll discuss
do
it.
we hear a
second.
Second, Dr.
If I have an apprentice working for me that I am sponsoring, he cannot go work for anybody else unless we sign one of those forms, the way I understand these laws and rules.
Right.
Is that not right? In other words, Bobby Colson can't use my apprentice unless we sign the deal. It's in this.
He has to have permission.
I think this complaint, you have the firm who's owned by the auctioneer, and he has an apprentice. Now this apprentice has been running a gallery
That's unlicensed.
And
using
his
that
sponsor.
auctioneer. So it's like they have their licenses over here with the firm. They don't have their gallery.
You left out a word, unlicensed.
Yes.
Right.
That's the key.
All right.
the licensed firm is not owned by the sponsoring auctioneer. It's owned by another individual. The person that answered is the owner of the licensed firm, but is not the same person as the sponsor.
Right.
So now you got a
It's the
third,
apprentice.
now you have a third individual involved.
Well, he's just the owner of the
I
firm.
understand.
Now, is he the apprentice?
No,
Is he an auctioneer?
no,
I don't believe so. I think he
No.
just owns the firm.
no,
Okay, well, see, I thought the apprentice owned the.
No.
The apprentice owns the unlicensed one.
Okay.
There's an individual who owns the licensed firm who responded on behalf of it.
Oh, okay.
Yeah, and that
That's
person-
other than the sponsor of the apprentice.
Right.
Well, I'm
Did your motion cover everybody?
It left out one guy.
It did now.
It won. It left out the sponsoring auctioneer of that firm.
The sponsoring one we haven't.
No, now that's not the way you just explained it.
No, you meant the
Argument.
owner,
We've got
the owner of the
you-
firm.
You said the owner of the firm was not an auctioneer, you didn't think. So you cannot hold a firm license unless you have a sponsoring auctioneer, and that's why I'm not interested in changing this rule we're bringing up to rewrite it like what it's rewritten today. Because I can point as many principals I want, one in each company. But when you say, oh, get on that line, say I sponsor them, then my license is in bigger jeopardy. And that's why I don't want to change. And it sounds to me, the more you talk, that's what's happening now. Because you just said that you didn't think that the firm owner was an auctioneer. So that means he cannot have that license unless he's got a sponsoring auctioneer.
Mr. Alexander, would you, I withdraw my second to your motion if you will make another motion to include the firm owner.
I want
We
to
didn't
include
include
the
the
owner of the firm and the sponsoring auctioneer if it is a non-owned auctioneer firm.
Is the firm owner an auctioneer?
no.
According to what she
I do
said.
not believe so. I could take a break and go check it just to be sure.
I can't believe that the investigator didn't find out all this and write this out to us and say, look, here's what happened.
Let's take about 10-minute bathrooms later. See,
They're
because
not-
you can
they're
be
not- they're not
like,
used to it.
at our company, Bill is the principal auctioneer, but I can sponsor an apprentice because I'm an auctioneer. And it could be a situation like
I
that.
think that's what she just explained.
It could be a situation like that.
Yeah, but if that's a
Or the auctioneer could not. Y'all ready?
Yes. Oh, I think it's back on. It's, you said you need this.
Oh, we're back on?
Yes.
Okay.
Y'all be happy to know the case.
I'm sorry. We checked it, the respondent 3, the licensed firm, is owned by an apprentice auctioneer. Separate one, not the same apprentice who is operating the unlicensed.
We got the diagram now.
What? Yeah.
Yeah, we don't have that board, we had that
Yeah, I
one.
need a plate.
You're
Where's
saying
this
what
for?
now?
But the firm is owned by an apprentice auctioneer. This is a different apprentice auctioneer.
So it's a non-auctioneer firm too.
No.
It's owned by an apprentice auctioneer, so.
And the apprentice auctioneer
Yeah,
allows,
but we still gotta have a sponsor
illegal
somewhere.
auctions to be conducted under his firm.
Yeah.
Well,
Does
You
he
got
have the
one,
same
two-
sponsor? Go ahead, Howard first, I'm sorry.
same sponsor, yes.
Okay, same sponsor.
You have
And that is
four-
the
you have
principal
four
auctioneer of the
individuals
firm.
and 2 firms. There's six entities involved in this deal.
One firm.
I only see 3 individuals, the 2
No,
apprentices.
You got the sponsoring auctioneer who owns the firm, his sponsoring auctioneer.
They have the same sponsoring auctioneer. Respondent
He don't
2.
know what's going on at all.
2 companies, 3 individuals.
And one real auctioneer.
Yes.
All right, so we have a,
Very nice.
A firm, by a friend.
a non-licensed activity,
Unlicensed gallery.
unlicensed activity
Ungallery.
on the gallery. And that is owned by
An apprentice, apprentice 1.
Then we have
His
the
sponsoring auctioneer.
firm
Where the
that this
apprentice
apprentice has his license
with, yes.
and his sponsor. And then the owner of the farm where the apprentice has his license
Is also an
also
apprentice
an apprentice
with the same sponsor.
with the same sponsor. So we got 3 people, 3 licensees, 1 sponsor, 2 apprentices, and 1 licensed firm and 1 unlicensed firm.
No, you got 2 licensed firms and 1 unlicensed gallery.
Gallery's unlicensed.
Just one licensed firm where they all have their licenses.
Where they all have their license and 1 unlicensed gallery.
Correct.
Well, now, who do we not have a complaint open against now?
We do, of those people we just discussed, there is not one opened against the 2 apprentices, the one that owns Respondent 3 and the one that owns the unlicensed gallery. Now, it doesn't seem, if we want, I know that you all said you wanted to open a complaint against the apprentice who is owning and operating the unlicensed gallery. If we do that, there doesn't seem to be much point in pursuing the unlicensed entity because you're getting the licensee who is running it.
No, we want to go to the head. I do.
It seems to me
I want
like,
to go to the guy that's sponsoring both those apprentices.
now that I see this licensed auctioneer is the guy who is dropped the dynamite. Because he's responsible for 2 auctioneers, and he's actually responsible for a firm. So I think, my opinion is the licensed auctioneer is the ringleader of the deal.
We won't know. till
That's
we have
respondent
a
number 2. We have a complaint against that person. Mm-hmm.
My motion, I want to include every one of them. The 2 apprentices, the sponsoring auctioneer of both apprentices, his firm,
And the
unlicensed gallery. And I understood you one time say that the sponsoring apprentice, the apprentice that was trying to help this other guy, had a firm license too.
There's just one firm where they all hold their license. Yes.
I just want the complaint.
I'm sorry if I said that. It's just it got confused in the.
misunderstood.
So you want complaints opened against the 2 people that we don't have them on? Because on so far the 2 apprentices. Now I think the other 3 that we have open should be. We should
Get
proceed.
everybody else in there.
We should proceed with them all at once. So don't take action on these for now. Just open the other 2 complaints. Bring all 5 back together at that point to determine what action we want to take.
What she said.
Yeah, what she said. If you
That's
got-
what I understood you to say. You want to open the other 2 complaints, and then we will deal with the
But I want to
consent
combine
order
them all
charges
together.
later.
Combine them all together.
We'll deal with them all as a group once those complaints have been
Good,
opened.
good.
Are you gonna repeat that motion, or am I just gonna?
Oh, you gotta do a
If
second.
Susan's got it, I think Susan's got it.
Well, I'll second.
So we have a motion by Marvin, seconded by Howard. All in favor? All opposed?
Well, that's clear as mud. Let's go to the next one.
Okay.
Yeah, that just got better and better.
Sometimes it's really hard when they're anonymous.
Yeah.
And I'm sorry, I tried to make
No,
it
you did
clear.
great. I mean,
Next
you-
time I'll do a chart if that'll help.
Well, that one was a little unusual.
Okay. Number 4 is 2012-018-301. This was originally presented at the October 2012 meeting. This was a complaint that was open based on an anonymous complaint which stated that respondent, unlicensed, frequently holds tack and horse sales and uses unlicensed individuals to hold the auctions. Respondent submitted a reply denying complainant's allegations of utilizing unlicensed auctioneers and stating that respondent does use a licensed auctioneer for its sales. Respondent included a copy of the individual's a licensed auctioneer license. Based on a check of the United States Department of Agricultural Packers and Stockyards Administration's website, respondent is listed as a regulated entity. Therefore, the recommendation was to dismiss. The Commission voted to defer the matter until the next month and instructed Council to request additional information. Pursuant to the Commission's request, Council requested additional information from respondent regarding when and how often respondent conducts auction sales and what types of items are typically auctioned at respondent's auction sales. Respondent replied stating that respondent holds livestock auctions weekly and holds monthly horse auctions. On the days that the respondent auctions horses, respondent also auctions tack. Respondent states that it is regulated, inspected, and audited by the USDA and state on a regular basis and has never had any complaints. So based on the fact that this was the additional information you all wanted, the new recommendation was to discuss it with you all.
Yeah, Marvin, I think you brought this up. It's how much personal property were they selling?
Well, I was just wondering if he's selling only personal property.
Right.
That's what I'm reading. I brought it up.
Okay.
Okay, do we have any?
His auctioneer is licensed.
That they submitted a copy of the
I make a motion we dismiss.
Okay.
Second.
All in favor?
Now,
Number 5, 2012-015-021. Complainant was a successful bidder on a property through an online auction conducted by respondent, a licensed firm located out of state. Complainant alleges that respondent required an out-of-state company to serve as the closing agent, which complainant believes is due to common ownership or fee-splitting arrangement based on the fact that the companies are across the country from one another. Complainant also states that respondent represented that the property title would be free of all past encumbrances, and complainant states the title indicates that fact, but the property had several hundreds of dollars worth of unpaid property taxes for 2011. Complainant also states that respondent's materials state that an individual holds an auctioneer license and includes a license number, but complainant states the individual does not hold such license. Respondent submitted a response stating that it primarily provides an online auction platform conducted by computers which allows for the sale of bank-owned real estate online, wherein the sale goes to the highest bid registered online within a specified time period. Respondent states that it also performs some live auctions of foreclosure properties in Tennessee as an agent of the trustee under a deed of trust. Respondent states that respondent is not affiliated with the escrow closing agent despite complainant's allegation. Respondent states that the purchase agreement instructs the escrow closing agent to prorate the taxes at closing, and respondent states that the settlement statement indicates tax prorations. Respondent states that any failure on the part of the escrow closing agent to prorate or pay for taxes at closing is between complainant and the escrow closing agent and not respondent. A copy of the settlement statement indicates tax prorations for the year 2012, and the settlement statement also appears to indicate a settlement charge paid from the seller's funds at closing for 2011 delinquent taxes. Finally, respondent states the complainant is incorrect and the individual does hold an auctioneer license and the license number is as listed. There does not appear to be a violation of tax statutes and/or rules by respondent, and therefore the recommendation is to dismiss.
Did they send a copy of the closing statement?
They did send a copy of this.
And the guy closed?
Yes, it did close.
Well, what's he fussing about? He should have not closed if he wanted to close.
I recommend we dismiss.
Is there a second?
Second.
All in favor?
Okay. 62012019751. This complaint was forwarded from Consumer Affairs. The complainants purchased a home in 2007, stating that they believed the home was located in one city and later found that it was located in another. Complainants alleged that the respondent firm auctioned the property and respondent received a part of the commission on the HUD statement. Complainants state that respondent may have advertised the property as being located in a different city than it is actually located. Complainants were from outside of the state, came into the state and looked at homes, including the subject property, with a real estate licensee who is not affiliated with respondent. Then later found out that the subject house had gone to auction, but the only bid was not accepted. Complainants then decided to purchase the house. This is after the auction. Complainants state that all advertisements, paper, contracts, documents, etc. state that the property was located in the mistaken city. Complainants attached a copy of the HUD statement for the sale, which includes the property address and states the property is in the mistaken city. It appears that the respondent received 1/3 of the real estate commission along with 2 other real estate firms. Respondent submitted a reply denying wrongdoing and expressing confusion over why the complaint was filed against respondent. Respondent states that the property was sold over 4 years ago and all information at the same address on it. Respondent states that all information received by respondent was given to respondent by the listing broker for the property. Respondent states that the property did not sell to complainants at auction and the property was sold to complainants after auction by the real estate licensee who complainants mentioned showed them a number of homes and who was affiliated with another real estate firm. Respondent states that several years ago complainants filed a complaint with the real estate commission against the selling broker's firm who showed them the house and the complaint was dismissed. Respondent states that the commission was split between the listing broker, the selling broker, and the respondent, the auction firm. Based on the information contained within the file, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
What were they hoping to gain from this complaint?
I'm not sure. It was filed with Consumer Affairs, so I'm assuming, Consumer Affairs can mediate things and obtain money for individuals.
Once again, they closed and the real
In
estate commission's
2007.
already dismissed it.
And they did buy it from them.
I recommend that we dismiss this case as well.
We have a motion by Mr. Morris. Do I hear a second?
Second.
Seconded by Commissioner Phillips. All in favor?
That's it for the legal report this month. Susan did email out with the agenda a copy of some of the rule drafts, and I know that Commissioner Alexander indicated he had some concerns with it, but last time we met in October, we didn't discuss this because Commissioner Phillips was still pretty new on the scene and hadn't had a chance to review, and I think there were a couple people that were absent as well, so we pushed it off until this month, and we're still in the stage of trying to iron out what you all want these rules to say. Also, if anybody, Commissioner Phillips, you particularly, if you have any issues that you think could be properly addressed by some new rules, then we're trying to gather all that together at this point, and so that when we start the official rulemaking process, we've got everything included. It's a lengthy process, so we're trying to address any kind of concerns that you all may have in rules before we start this process. So if we want to go through them one by one, or Commissioner Alexander, if you want to start with your concerns, we can go however you all want.
To me, if you change this like this, you're changing the law on this completely by rule.
Okay.
Because I had it marked in that other book, all these notes wrote down, but I think we got a different one here now. I got to find when the non-auctioneer firm license was first set up. What is it?
Are you looking for the rule or the statute about?
Look at the statute.
The statute is 6219-111 is the one that deals with licensing, and the firm application part is subsection H.
When was this?
The statute, I believe the last time it was, looks like the last time it was amended was in 2008. It looks like it was originally maybe done in 1967. I don't have notes as to what particular changes were made the last time.
2008, we were working on that, didn't we?
That is not the one about a non-auctioneer firm.
This is the licensing statute. There's
I
another.
understand, but maybe it's all in the rules.
The current rule that references that is Rule 01-01-.16, and that deals, it's titled Non-Auctioneer Firm License Application.
there's one before this. There's one before there that's in here. When the first time we set up the non-auctioneer firm, and I thought that was in the statute, it might not be. But then it comes back in a different place and says that the sponsor must attend all auction sales. I thought you'd remember that, Miss Donna, because you didn't like that word sponsoring. Thought you could quote
Oh,
that
I
to me.
think I know the rule you're,
I'm thinking it's in the rules rather, but I'm looking through the statutes.
It may-
okay, I know where I'd circled it in one place, and this may have been because of a discussion about that. Rule 0160-01-.05, it's titled Publication of Name, but it says, all advertising in auction sale by an auction firm not owned by a licensed auctioneer shall include the name of its sponsoring auctioneer, and the auctioneer shall attend all auction sales. Is that the
Right.
one you're referring
I want
to?
that part, and then there's another one that said that before that said they had to have a sponsoring auctioneer.
There's, the statute states that
Okay, here it is.
they have to have a principal.
0160-01-05. All advertising of an auction sale by an auction firm not owned by a licensed auctioneer shall include the name of its sponsoring auctioneer, and the auctioneer shall attend all auction sales. But they had to have the sponsoring auctioneer to even get the firm license.
Well,
So if you come back and you say, well, the firm non-owner, firm license, we're talking about a non-owner, and somewhere in there it addresses non-firm owner.
it's in 111, and it says that they have to have a principal. In the statute, it calls it a principal.
Well, that's what we need to change. We need to change that principle to a sponsoring there then.
Well, we can't change the statute, and unfortunately, the statute requires, it references, it says a firm licensed must be issued in the name of the firm with a specific person acting as principal and holder of a valid auctioneer's license. Then just below that it says the applicant, if not a holder of a principal auctioneer's license, has completed 30 hours of rigorous classroom education. So it's basically saying if it's not a person with an auction.
We passed that rule, or if that's the only place that's in here, to allow a company that didn't have, that owned a company, like a real estate company, or could be another company, that they could get a firm license and operate business as long as they had a sponsoring auctioneer that was responsible for that. That's on. I was here when that was passed. That's the only reason that was put in there, was to make it easier where you'd have some control over the companies, because they weren't auctioneers. But if you just say, if they can't get a license, they can't own a principal. And they can't get a license, the way we set that up, or at least that's the way it was governed up here for 25, 30 years.
Well, right now, and Donna, correct me if I'm wrong, if somebody applies for a license, we have in our licensing system what's called a principal auctioneer for a non-licensed firm, like this statute references.
Correct. But Marvin, under your scenario, if you had an unlicensed real estate company that wanted to get an auction firm license, you're saying they would have to have a sponsoring auctioneer. Would they also have to have a principal auctioneer?
Yeah, it could
And
be
who-
one, it could be one and the same if you wanted to, but it wouldn't necessarily have to be. And this
Well-
was, also was in whenever, there was people that owned barns, livestock barns and what have you. And if they wanted to go out and sell, not sell cattle, they could have a Packard stockyards and not have to have a firm license. At one time they did, and we changed that. Because I was up there at the legislature the day they changed it, they had it wrote wrong, and we got it changed. And then, but we did that, if they wanted to get a regular firm license, say to sell furniture in their auction barn, they had to come get a firm license. And if it was owned by a non-auctioneer, then they had to have a sponsoring auctioneer, not just a principal. A sponsoring auctioneer. That's the way it was set up. Now,
If it was owned by a non-auctioneer.
and it stayed that way until the date that Mr. Wayne said that the people in Knoxville just had to have a principal. It didn't matter because the guy that had left and somebody else had it was a non-auctioneer. For years when I was up here, every time I served on this commission, whether it's right or wrong, it may not have been right.
So that was for big corporations could hire, I know some did hire a full-time auctioneer to sell their own wares.
At one time, they even deeded them a 1% of the company or the corporation. That's the only way they could get a license. That's the only way.
So, my question is, what's the hang-up right now? I don't understand.
With the rule, the way Julie's written, Commissioner Alexander, I think feels like there should be more language in there about a sponsoring auction.
What did you change?
Well, the way the rule was, it says non-auctioneer firm license application, and it seemed a bit confusing as to what it was trying to say. So the way I had read the statute, because it did not mention principal, it just mentioned, it did not mention a sponsoring auctioneer, it just mentioned a principal. I tried to redraft the rule to clarify that, but it appears that what he's saying, there's a requirement there that I'm not seeing here in the statute of the sponsor. It just references the principal, and in the statute, the only place where it appears to reference a sponsor is in the context of a sponsor for an apprentice. So I was trying to make some consistency between the rules and statutes so there wouldn't be as much confusion, but it sounds like there was a different intent here.
The word sponsor is not mentioned in the code, in the TCA,
Except for apprentices.
except for where apprentice is sponsored. And that person, there's no definition of what a sponsoring auctioneer is versus what a principal auctioneer is.
Yeah, well, I brought that up one time. That's all we needed. I think I sent you, I might have forgot to mail it. Under the definition, all we had to do was put in there that a sponsoring auctioneer was someone who sponsored a non-auctioneer firm.
Or a principal.
Yeah. Well, they've already got it in the definition for
I
an
know.
apprentice. Yeah.
Yeah, you
Marvin,
have the
I-
same,
Why do you, and I'm just asking a question, why do you need a sponsoring auctioneer instead of a principal auctioneer?
because the principal auctioneer may not be associated with the firm.
Well, he had to be their principal auctioneer.
No, he don't even have to be around.
No.
He just got to do their auctions. What if you had 3 offices? You can have a different principal auctioneer in any office.
You're saying the sponsoring auctioneer has to be there on site at all times?
I'm not saying he has to be there, but he's responsible for that auction, and he had to attend.
any and all activities.
And he has to attend every auction.
But
Just like
A
this
principal auctioneer don't have to attend every auction.
But I guess the problem we're having here is the statute doesn't require them to have a sponsoring auctioneer to get a license. Right now, it just says they have to have somebody acting as a principal. We have a principal auctioneer listed in our licensing system. There's no requirement in our statute that there has to be a sponsoring auctioneer the way it's worded.
Till we
It's
got
just-
that rule,
There was.
corporation, a real estate company that was a non-auctioneer could not get a firm license. Could not get a firm license.
She's saying the statute allows for it.
I'm not, maybe it didn't, but that's the way it was always interpreted. It said over there that,
And that what you're saying, Jim, that a firm can get a license without a principal auctioneer?
A non-auctioneer owned firm has to have someone acting as the principal auctioneer, but it does not mention sponsoring auctioneer
Well,
at all.
you're using those words interchangeably.
well, it says
I don't think
sponsoring over
so,
here.
'cause he's
When we
saying the
first got it passed,
principal.
it
Well,
says sponsoring.
Marvin, I'm confused on,
It all gets down to a non-auctioneer firm. That-
I know, but a sponsoring auctioneer, who is he sponsoring?
The firm.
If you hired me at your firm, at your hotel chain, you've got a non-auctioneer firm
No.
license, and you hired me to be the auctioneer,
I have an auctioneer's license, so that won't apply.
but you don't under my thing, you just on a chain of
He
hotels.
took it from you.
And you're going to auction off some of them sometime or something. So you hire me, you get you a non-firm auctioneer license, and then you hire me to be the principal auctioneer. I'm still responsible for everything, aren't I? I don't either.
I just know that the only reason that was put in was because if you're a real estate company that did not, if the owner, he could have a real estate broker there with an auctioneer's license, but if the owner of that company did not own part of that company, or a corporation didn't own part of it, that had somebody in that ownership had to have an auctioneer's license or they come under a different deal. And that's why we got that passed where they could. But he had, and he said, that's why it says the sponsor had to attend all auctions.
Well, when we're asked that question about applying for a firm license or a gallery license when the owner does not have an auctioneer's license, we have a chart that you all adopted to 1 of 10 that says that, and at that time Adrian was writing rules. Adrian Chick, who was the attorney at the time, was writing rules. And you all were requiring that non-auctioneer person, in order to get a license, to have a 30-hour course of education and pass the exam for a non-auctioneer owner. So that's what we do now. We say you got to take a 30-hour course on operating a business, and you got to pass the test on operating an auction firm, and then you've got to appoint a principal auctioneer to be in charge of your auction. And so we issue the license to the non-auctioneer owner.
But it's assigned under a principal auctioneer.
Yes, so you have to have a principal.
Right.
And does that
That is your
auction-
sponsoring auctioneer that you're looking
Yes.
at.
and
What
Does that principal auctioneer have to be at every sale himself?
What if we specify in the rule just that the principal auctioneer for this firm has to attend every sale? Just use the word principal so it goes with the statute. The statute requires that there has to be someone acting as principal. So if we take that a step further in the rules to say, in this context, if you're a non-auctioneer owned firm, your person that is your principal has to be at all sales, has to sign. What if we just use the word principal for consistency with the statute? That way it's separate from sponsoring auctioneer in the context of an apprentice's sponsor. And we can set that rule that this principal has to be at all the sales. And then it matches with our statute.
I think that
We think, Marvin.
You know, just as long as we don't lose that control, because I think it's going to wind up when you do that, unless you do define it, it'll be just like the gallery license. We don't have any control over the gallery license, man. We just discussed we can't even send them a fine.
I've always thought the gallery license was a joke.
Well, it wasn't a joke. It just put everybody want to be an auction business in it, without any
Without an
scrutiny,
auction.
other than 30 hours, I guess.
Well, right now, the way the non-auctioneer firm and application and gallery. Gallery, does it say principal?
Yeah, don't some of those.
That they have to have a principal somebody sign that application and it says that they know that they'll be responsible for sales, blah, 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 and that they're acting as principal or sponsor. So we have a licensed auctioneer to hold accountable for a non-auctioneer firm. And the owner of the non-auctioneer firm has to take the 30 hours of the test.
Julie,
We're not. Go ahead.
are we clear for that?
Well, I don't know if this address, it sounds like Commissioner Alexander still has some concerns, because I thought that the verbiage of a principal and a sponsoring auctioneer was just a matter of what you chose to call it, if we required the same things from them, but he doesn't, you don't think that there will be the same amount of protection if we call it a principal auctioneer?
I sure don't. Because I can point, here's the point. If they're a non-auctioneer firm, they can't, how can they appoint somebody before they get a license? That's like getting a chicken before the egg.
Well, there has to be a licensed principal auctioneer for them to get the license. It has to be somebody that has a license.
Well, it says in that 105 said all advertising must be in the name of the licensee who shall bear responsibility of the sale to the seller, general public, and auctioneer commission. Whose name are you going to put on there, the firm or the auctioneer?
Which one are you looking at? You said 05?
Under the rules. I think the problem we made, we just never did put a definition in there of a non-auctioneer firm. You know, and if we had done that, had that other down there where it said,
I thought there was a definition.
where it,
I don't believe there is right now, and as part of the revised rules, I put as subsection 1, a non-auctioneer owned firm is an auction firm which is owned by a person who does not hold a Tennessee auctioneer's license. Then it goes on.
where is that at?
This is in the draft of the proposed rules I have here. We don't have a definition of that
No, there's
right
discussion
now.
of the application.
There's discussion of the application in the rule as it stands, but some of my reasoning for amending this rule was to define what it is and then, clearly try to state that in their application, they need to have one licensed auctioneer to serve as their principal auctioneer who shall attend and accept responsibility for all auctions for the firm at each location involved in auction sales. This is subsection 3 of the proposed rules I drafted. I would, think that it would then place the responsibility on that licensed individual by crafting it this way.
So where is the definition that says what a principal auctioneer is responsible?
We don't have a definition of principal auctioneer right now on these proposed rules. The very top one was one that the very top thing right under the heading is a definition we had discussed.
One thing I'm saying is you've got a company, it's a non-owner, and if they've had a sponsoring auctioneer, and evidently that's what it was meant if it's on the application, then the application show who the sponsoring auctioneer is.
Shows the
And it
principal.
listed as principal, that's the common auctioneer.
Well, if he leaves, or say he leaves, and there's 5 other auctioneers, and they don't never notify one, there's nobody responsible.
Well, and that's another issue we were trying to correct by changing this rule. You'll see number 4, we were trying to add in that they must notify within 10 days of their principal auctioneer and have someone in place within a specified period of time. So we were trying to address some of these issues. Now, I know that you have concerns that it's now calling it a principal instead of sponsor, but my reason for choosing that word instead was so it aligned with the way the statute was referring to
I
it.
think that's correct to do that.
And on the real estate side, if they're selling real property, the principal has to be the same as the principal's owner.
Right.
What did you just say?
If they were gonna sell real estate or real property, you have to have the real estate firm license, the auction firm license, and then the principal broker has to be the same person that we have listed as principal on the auction license.
The auctioneer has to be the broker, is what you're saying?
According to real estate, so we've had that question pop up in the office, and
They make them have the same name, firm name, but
No, I don't
the
agree with you
principal
on
broker
that.
can be
I don't
different
think we
than the
have a
principal
statute.
auctioneer.
Never heard that.
I don't know that.
If I have Alexander Auction Real Estate sale and John blows a licensed auctioneer here for me, I can let him go have the sale.
If he's not your principal auctioneer.
I know that he's not, so, but he can still have that sale.
I understand that.
But that's not what she just said.
No, she was saying the principal auctioneer and the principal auctioneer and the principal broker had to be the same person if they were.
Yeah, but that ain't right. I'm the principal auctioneer in my office, but I can let another auctioneer go have a sale.
I know, but your firm has to have a principal broker and a principal auctioneer.
But they don't have to be one and the same.
That's what they're.
That's what she just said. That's, am I not right?
If
That's
it
what,
was a non-auctioneer on the firm, because you have to have that sponsor, principal.
Oh, if it's a non-auction.
Yeah.
I'll agree with that,
Yeah.
but I don't think that'll be that way when we get through this, but it's fine with me.
I don't see the loophole.
There's a loophole there. There's a loophole, it's just like the gallery. It just makes people think when you've got a sponsor rather than just a principal auctioneer. Because if you got 10, you can just appoint one and say, well, I appointed him, but I forgot to send it up here.
Other than the second rule that Julie's written, are there any other?
Now, none of this is chiselled in stone yet anyway.
No, I haven't even put numbers on it yet
We
because
need
I
to-
thought there might be more. Now this one has a number on it because it's a revision to a current rule, but all these other ones I haven't even put
That
number.
seems to be the sticking point. If we can get the others okay, then we can discuss this one over and over and over and over for another 3 years.
I think the way it's written will work.
I personally like it too.
Well,
Clear.
I'm not sure.
I'm not sure either, and I,
Well,
since
let's do
I've
it.
seen
Let's
the
do
source
this,
of
guys.
this, I know where Marvin's coming from, because being a commissioner for 9 years went back a ways, and there was things happening in some of the rules that evidently wasn't what we thought they were when we made it.
That's the nice thing about rules, you can always change them.
Well, can we skip?
Julie, what's your timing on this? In order,
It's up to you all, and I
I mean,
don't
in order to
want.
make it into the calendar for next year, when do you have to have this adopted by us?
It's a we
It's
have
a
to
lengthy
set the. It's a
process
lengthy
anyway.
process. I'm not sure I could tell you when these will be done by because it depends on I mean, we would have to. I have to have it approved through the assistant
Best case
commissioner's
scenario.
office.
6 months.
Yeah.
Yeah, if you said, yeah, this is.
Probably best case, 6
If you
months.
want to be in the upcoming session, do you not?
No, this has nothing to do with
It doesn't.
legislature.
It doesn't.
No.
These
Yeah,
are our
these
rules, and
We
it's
we
just-
have to send notice to membership. and all
Oh,
that.
okay, okay.
Yeah, it doesn't have anything.
I'd prefer that we are sure that these are the way y'all like them and that we have everything included together because it's such a long process. It's probably not a good idea to say, we'll pull this
Yeah,
rule,
all right,
and
well,
let's
we'll
go
pull the
ahead.
trigger.
We want to be sure that.
Did you email these to us, Susan?
Yes.
Okay. Guys,
He did, and I haven't looked at it.
All right, that's my point. If we will make it a promise to each other that between now and the next meeting, we will really read them and make any edits that we feel like that we have to make.
Or put okay next
Or
to the
put
ones you're
okay
okay
by
with.
the ones you're okay with. Let's all agree
And
that
then we can
we
take-
won't just put this off to the next meeting. We'll study it between now and the next meeting, and then make it go up or
And
down.
then
or
try to
make
act on it.
And then act on it at the
I
next
agree.
meeting.
And also any addition, I mean, if you all think of something in the meantime too of
But
an
let's make
additional
a concerted
topic.
effort. Julie's done her job. We need to help her complete the task, if we will, by reading it and giving our input either up, down, or sideways. And that's what I would suggest that we do.
And I'll be happy to be sure, follow up with Susan and have it resent to all of y'all right after this meeting just to be sure that you have it.
Is our calendar call for a meeting in January?
No, but we have one at the beginning of February.
All right, so between now and February, that gives us,
I think between now and then, we ought to be able to look at it.
you got, that's, gives you 60 days to study, know it, make whatever changes you're gonna make.
It's gonna be the same thing you've already sent us, all right?
Right, and it's just for you all to review it.
I just put it down.
Oh, it is
Went
great.
down on the first floor.
I can read it on my screen.
That's where that
Okay.
came from.
When all that came, okay.
I've got that too, don't I see?
And while you're
I'm more
reviewing,
paperless now than some other people I know.
while you're reviewing these, she has given you the TCA that she's taken this rule from, for you to refer back to, because she can only write a rule that comes from a law.
Right.
Well, if we, I know.
So
we
our
don't-
homework assignment,
Yeah.
Mr. Chairman.
Right, we have a homework assignment. But I know we don't print law books anymore, and it's can we take something with us, the law, the copy of the law that she changed, where I don't have to get online, try to look it up?
Y'all
You got something with you?
Copy of the rules.
I would, in
and-
fact,
No, I'm talking
I was
about the law.
gonna ask if we could download the rules and the law of this onto our,
How about we just, I'll send you all copies.
Yeah, just
that'd be
email
fine.
it. Yeah,
That'd be
work.
fine.
Yeah,
That'd
I've
be
got
fine.
PDF copies.
All right, yeah, send me a PDF and I can look at
all.
it.
Then I'll send it with another copy
Well,
of the same rules. just so
All
we're all
I'll
good.
have to go to
All right.
the website and try to look it up.
Julie, would you look at that number 6 in the law? On the second page,
I'm sorry, which one are you talking?
number 6 about the firm.
In the law.
Yeah, that would be number three.
Sponsors is mentioned again, other than just in the firm.
In the statutes.
That's in the statute. I'm talking about in the statute. Look at 6 on the second page of the statute. About a firm.
What?
I mean, I'm assuming that's what y'all.
What TCA section?
Oh, it'd be the first
One-
one.
160.
Chapter 101,
Yeah.
6219-101, under definitions.
1600114, number 6.
Firm means any person who,
As a part of the person's business.
So there was a
Is that what
place.
you're looking at?
So there was a place to tie a sponsor and auctioneer to a firm.
I think she's looking at that as sponsoring apprentices.
No, it's not. It says 6. Number 6, firm. Firm means any person who, as part of the person's business, arranges, manages, sponsors, advertises, or carries out auctions. And that's what we was expanding on, I think, over when this thing first came up.
Well, okay, and where I was expanding it from was from 111, the licensing provisions, which
Well,
state.
this is the licensing provision, ain't it?
Well, number 111 is titled General Licensing Provisions, and that lays out what you need to get each type
This
of
here,
license.
but I'm looking at the chapter definitions.
Yep.
And I think that's what we expanded on when we made that rule. Might be wrong. But then there's another one over under B that says, all auctions arranged by or through a firm shall be conducted exclusively by individuals who are licensed as auctioneers under this chapter. But I'm ready to move on.
I understand. Let's do our homework and,
Come back in February and see what we can do.
exactly. But let's get up or down in February.
Would you send us a copy of those applications?
Yes, I'd like to see what those applications look like.
We
So,
will. Y'all want PDF copies or hard copies?
PDF.
PDF, fine.
You just want the farm and gallery?
I want them all.
applications?
Are you in every application?
Yeah,
we got?
yeah, why not? More the merrier.
You know they're on the website.
Oh, if it can.
Oh, okay, well, I know the website.
They are on the website.
Okay.
Just look right through every question.
The website's got
I ain't got
more
you.
difficulty to navigate, maybe.
But we send you a link to the website.
No, I can get to the website, it's finding stuff after you get there. that
Forms
kinda
and
confuses
downloads.
me.
Click on forms and downloads, and they're all right there. All
All
right,
right,
are
we got a complaint comparison report.
Yes, are you ready for me? Tab 4.
I'll tell you what, let's do, let's go to the bathroom again, about 10 minutes.
All right. 10 minutes.
Gotta get this back on, get it on the right thing now.
Get it figured out tomorrow. All right, so we're back to the complaint comparison report.
Yes,
We're through
tab
it
4
anyway.
in your books.
That's what I understand. You have to go
Um,
to, county touch library.
I know we got touches.
Yeah.
Oh, okay.
He's got the Midas touch.
Under tab 4 is our standard monthly report comparing where we are this year, where we were last year with our pending complaints. You'll see that October 30th of 2011, we had 79 complaints total that were pending. 59% of those were over our benchmark to resolve these complaints within 180 days. This year, the below grid, November 30th of 2012, we had 57 pending complaints, 63 of which are over that 180 days, but we know that approximately 40 of those are against one respondent. So,
When will that come off of our list?
Mr. Chick was supposed to be here today, I think, to give us an update.
I saw him about 3 minutes ago, I should have said something.
Yeah,
Saw him at all.
as far as I know, well, I'm not going, I know what I know, but I don't know enough to pass it along to y'all, so I'm just.
And I really don't.
Whenever a complaint is final, and I had someone ask me this at the convention last night. I thought I knew the answer, but I wasn't sure, so I told them that I asked. Whenever someone files a complaint, and then we do our thing, it's all of is a letter sent to the person who originally filed the complaint.
Yes, unless it was anonymous complaint. Yes, the complainant gets a letter telling them how the complaint was resolved, whether it was dismissed or
Whatever.
civil penalty or whatever. Yes.
That's what I thought.
All right, if there's no questions on that, we'll, there's no, on the next little issue, there's no tab. I just wanted to publicly thank Chairman Colson for accompanying me on October the 2nd up to the legislature to the public hearing by the Commerce, Labor, Transportation, and Agriculture Joint Subcommittee of the Government Operations Committee, where they went over and heard the audits that were performed by several boards, the Auctioneer Commission being one of which was audited, seemed like for 2 years, but I know the auditors were in the building for 6 to 8 months going through everything. There was one finding against the Auctioneer Commission, and that related to the Education and Recovery Fund. When those funds were depleted 2 years ago, 3 years ago, they took that fund down to below $150,000, where the statutes say it has to stay. It can't go below $150,000, and money to be spent out of it, and that was the problem. Once the funds were depleted below $150,000, we continued to pay for our contract with National Auction School, and that was finding. So we had to we file reports saying that from now on, if the fund goes below 150,000, we will go to the general fund if we need to pay our contractor. And that I will bring it to the attention of the commissioner, the assistant commissioner, or they'll bring it to my attention if those funds are taken again. So we're going to watch that more closely, stay in touch. If it does go below 150,000, we'll look at the expenditures of the general fund.
Well, the fund was rated, it shouldn't have been rated anyway.
Exactly.
What,
we couldn't hardly say
where does that
that.
fund stand today?
We're going to go over that in just a minute. That's next.
But bottom line is, we got renewed for 5 years.
We did.
And it was very interesting, listening, watching the whole thing, the process.
Yes.
We got lucky we didn't have the same thing. We just sat back there, but there was a couple of the boards that they got up and raked over the coal pretty good. It was pretty
You didn't have to do any auction.
we didn't have to do it.
Dodged the bullet.
But it was interesting.
Yeah.
That's a sign of a good leader.
Well, I credit that to Assistant Commissioner Giannini, who got up and spoke and explained the audit findings to the committee. So, anyway, I want to thank Chairman Colson for going up there with me.
It was a good experience. It was great.
If we have no other questions about that, we'll move on then to tab 5, which is the budget report. Well, I do have, toward the end of October, I received the final closeout budget report for fiscal year 11 and 12. And that's the right-hand column under the first page under that tab. You'll see coming down the right-hand column, total payroll expenditures was $121,112. Coming on down the other expenditures, and if you have any questions on any of those expenditures in that right-hand column, let me know. But they total $167,132. You look at the cost backs, were a total of $69,306. That's in administration and investigations. They made your total expenditures $236,438. You take your total revenue of $277,506. Then you take away the state regulatory fee of $14,385, and that's paid to the Department of Revenue each year, $5 per licensee. That leaves the net revenue $263,121. You take your net revenue, or your total expenditures from your net revenue leaves $26,683 for the 11 and 12 fiscal year balance. The prior reserve from last year was $129,299. You add that to the $26,683 for a total $155,982.
What jumped the travel up 21,000?
That was,
I'm surprised we got travel approved.
part of that was the witnesses that came in for the formal hearing against the respondents with 40 complaints that never
And we
took
had to
place.
foot the bill on that.
It was like 18,000, wasn't it, total? That hearing was supposed to happen in June, but by the time all of the bills and the things came in, it came out of, started in fiscal year July.
So we have 2,877 licensees.
You were doing the same thing. I was just down 2,937. That's just because people always ask. They asked that question last night to the commission, how many licensees do we have? Well, we're done. I meant to call you.
2,877.
So we're going now.
Yeah, and there'll be some other indications of that, and if we go on through the report.
We're down to 60 people, down 60 licensees year over year.
The next page is
Percentage license.
under the tab,
Percentage license.
explains the cost backs and how that administration averages each board's share of the cost tax.
2%.
Have any questions on that, let me know. But it was 69,306, and that was what was on the report I just read to you. Now, at one of the last meetings where we discussed the budget, I believe Commissioner Morris asked for us to break down our revenues so you'll know where the monies are coming from, and maybe we can see then a dip in anything or a change in any particular license or renewal pattern. So we've got the Auctioneer Commission Revenue Comparison Report by fiscal year. Again, you've got fiscal year 9 and 10, 10 and 11, 11 and 12, and then year to date through October 30th is where our fees are coming from currently, year to date. So in that right-hand column shows you just we're keeping up with the money that comes in from initial licenses from auctioneers, apprentices, colored auto auctioneers, initial reciprocals, renewals, reapplied, upgrades, transfers, retires, miscellaneous late charges, late fees and charges.
Fortunately, the lion's share of that's renewals, so that's...
It is. But if you look at 11-12, the final fiscal year closeout for initial licenses, we only received $1,059 from initial licenses for auctioneers and apprentices last year. Whereas before that, 9 and 10 was $14,000, 11,500. So there was a big drop off in your revenue. Everything else pretty much consistent.
Yeah, but your renewals are way up.
Yes. Well, that was up for renewal year.
Right.
Well, they weren't way up, but they 20,000 maybe.
Well, it offset the difference.
Mm-hmm. But then your firm is at the bottom, firms, galleries, initial applications, reciprocals, renewals.
That's almost all renewals there.
Yeah. But as we get closer to the end of fiscal year, you'll be able to see the differences in the patterns.
I think that's a good chart to have, to try to see what the trends are.
Well, on the next page is your comparison of expenditures, and we've got the same thing. We've got giving you a pair 9 and 10's expenditures, 10 and 11's expenditures, the final for 11 and 12, and then the shaded column is where we are right now, year to date through 10/30/12.
Right.
And so,
4 months.
yeah, showing you where we are with payroll, travel.
Third of the year.
And then the comparisons for the last 3 years there. If you don't have any questions.
What would fall in the category of state professional services?
State professional services are, that's rent on office space, that is billing through the Attorney General's office, and that's services from data processing.
Okay. The investigators down here, separate line items there. That's where they charge you back.
Right.
Okay, I can see.
Yeah, they cost us back for it. And the last report under that tab is the Education and Recovery Fund report. This is another thing I'm going to be doing for you, is giving you a monthly total of how much is in that fund.
That's good.
We're giving you a 2-year comparison report there, 10 and 11, 11 and 12, where we stand right now on the expenditures. So far, we've only spent $3,411. With total revenue is $16,200 for the fiscal year balance of $12,789 through October. Then your last year, what was in your reserve was $190,205. So add that to the 12. Currently got $202,994.
As far as revenue receipts, that's in new license applications, is that what it is?
No. This is, every applicant pays $50.
That's right.
And renewal pays $50, so
You
it's a
haven't had
separate
any,
account.
you haven't had any revenue so far?
Yes. we've got,
It says 0. Revenue receipts.
oh, I'm sorry. They've not reported anything to us yet. This all
Okay,
comes to us
okay.
from administration, and they've not given us revenue on that, but there's some there.
Okay.
The thing is, there's Edison where accounts, there's revenue where renewals are paid through, and there's online renewals where all that money has to come in and be accounted for, so. That's all I have on the budget.
We're in some pretty good shape, it looks like.
We're watching it. Let's just say that close, more closely.
So our little Asian guy back.
Yes. Excerpts under tab, let's go look at tab 6. At the top of the first page there, I had Susan copy the excerpts from the minutes of August 6th and October 1st.
Under the education provider application, tab 6.
Yeah, on October the 6th, I presented this to y'all the first time from Easy LR 24 Online Training School. And you want me to request some additional information from him regarding his instructor qualifications. So I brought that back in, what he resubmitted, and at the time, in October 1st, you asked that we defer this matter, since this was Commissioner Phillips' first time to kind of look at it, to just bring it back again. Then I've copied the rule there that says that in order to qualify for credits towards satisfaction of continuing education, the requirements, a continuing education program must be a formal program of learning which contributes directly to the professional competence of the licensee, and a sponsor of a continuing education program shall obtain approval from the Commission as provided in this chapter, and formal programs requiring attendance may only be considered for approval by the Commission if they include an outline, there's 2 hours, at least 2 hours in length each unit, and the program is conducted by an instructor, discussion leader, or lecturer who is qualified in the opinion of the commission. And then they keep registration of attendance. So what he has sent is his course outline, showing it's 6 hours, and then his application. His resume, I believe, is in there. Yes.
Our biggest concern on this deal was, this guy's in the school business. This little Asian guy, he's got this online course that down in Texas and North Carolina, and he's in lots of different states around the country. He's trying to get us to approve an online course for Tennessee. He has no background in auctioneering at all. What he does is he takes the laws and statutes, and he designs this course written around those and manipulates that into a course that you take, and he gets paid money for doing it. And
Well, apparently everybody,
right. So,
electrician,
am I summarizing that
refrigeration,
pretty correct?
Yes, you are.
cosmetology.
Yeah, I mean, he's in the school business is what he is. And it's all online. He teaches nothing. It's an online. He's a internet guy.
He's never had any actual experience in the auction business.
0. Barely knows how to spell the word auction. And I just have a problem with it myself.
We must have an easy license renewal. Let's have an easy vote on it.
Well, as far as I can tell, he still failed to send us an outline of his
Yeah, I don't see anything in here.
program. So that would be a basis, I think.
Well, and it does say, I'm sorry, not to interrupt you, Donna, I'm sorry. Under the third factor, 016, I think it's part of the, under Part C of the part of the rule that Donna copied for y'all, it says the program is conducted by an instructor, discussion leader, or lecturer qualified in the opinion of the commission by either education, experience, or both. So that's another, that's up to you all to determine.
In my opinion, he doesn't
that's
have
good rule right
qualification. And I make the motion that we not approve it. So.
Second.
I'm sorry, what did you say, Judy?
Oh, I was just pointing out subsection C saying that the program is conducted by an instructor, discussion leader, or lecturer qualified in the opinion of the commission, and just pointing out that factor, that's something that's for their
And we have a
consideration.
motion by Commissioner Morrison says he doesn't feel like that he's qualified by what you read there.
I will send him a letter.
Second by Howard, all in favor?
All right, we skip tab 7 because we've already covered that with Mr. Smith. Move on to tab 8 if you would, which is a discussion I would like to have about absolute auctions. Had an auctioneer call and then send in those 2 pages there. You see, one's real dark, it was hard to copy. And I think expected me to open a complaint immediately based on this. Talked to Julie. We decided to just redact out anything and everything that might indicate who the names of any auctioneer or auction firm on these flyers, and ask you if the verbiage on these flyers is a violation.
It is a violation.
Because it says, for the record, absolute auction above mortgage online only. That's the first one. The second one says absolute above mortgage and closing costs. So I thought we've had discussions about this before, and I wasn't clear that that kind of verbiage is a violation.
It should be. There's only 2 kinds of auctions. And I get into this, I get heated about it.
Yeah.
There's an absolute auction, and everything else is a reserve. If you say that it's absolute above mortgage, that's a reserve auction. It is not an absolute auction. And there ought to be a fine issued when they advertise that.
So why can't they get that? That's
Because they're trying to get they know the power of the word absolute, and they want to include it in any way, shape, form, or fashion in the advertisement they possibly can and get by with it. And until this commission holds their feet to the fire and starts issuing severe penalties for advertising like that, they're going to continue to do it.
And you know, I just wanted to point out in our rule that we have the advertising guidelines. We have a subsection that states, and I'll summarize it because it's a little lengthy, that if you have a sale where some items are with reserve and some items are without reserve, it does specify that the font size, style, and case of the type publicizing the part without reserve should be the same size as with reserve. That is not exactly what we have here. So that might be a consideration for a possible rule stating, you know, just for when it, that if it states absolute auction, all font, you know, any.
Well, what your rule needs to be, if you advertise an absolute auction, there must be 0 contingencies upon that being an absolute auction.
And that might be something.
It cannot say absolute with the bank approval, absolute above the mortgage, absolute if we get a high enough bid, absolute if above this minimum bid. I see them all that way, and they're all false advertising.
Or misleading, deceptive.
It's false advertising.
I
Period.
think that would be a great newsletter article for the
Well,
next.
there's been a dozen newsletters about absolute auction, and the gentleman is correct. Until you start giving them a penalty stiff enough or put them out of business, they're going to continue doing it because it's the most powerful word in the auction business is absolute. And this is the most misleading to the public, and that's what we're supposed to be here to protect, and evidently we don't because we're still letting them get by with running absolute auction ads subject to a reserve.
Do you think?
That's what I've got to say.
Do you think, though, that it might be helpful to add in our rules, though, to say if your advertising states absolute, there must be no contingencies? Because I imagine what some of these people think is because they're putting on here, even though it's in a much smaller font size, absolute above mortgage, that they're not technically making a false representation, and maybe we could kind of make that a little.
Whatever we need to do to tighten that up, I'm in favor of it.
So something.
You need to be careful too, because you don't want to get into, and I may be wrong on this because I'm not licensed in Kentucky, but I've heard some things about it where it's, in Kentucky it's got to the point that they say you can't even have one one being an absolute auction if there's back taxes against it.
You cannot have an absolute auction in Kentucky if there's a loan on the property at all.
Unless you get them to sign off.
Right.
Agree to it.
Right.
You get them to
Well,
agree.
you can do that in Tennessee, as long as they go, they may have to take money to.
Well, I mean,
pay
in
for it.
Kentucky, if I'm hearing y'all right, and what I've heard, if you've got a $10,000 loan on a house that's gonna bring over $300,000, you still can't have an absolute auction unless you get the lender to sign off.
That's right.
Correct.
And a lender would be nuts to sign something on that. If I was a lender, I would.
Well, wait a minute.
But
Well, let me ask you this, only thing I have a problem about getting this, we can make all the rules we want to make up here, but if you can't enforce them, it just gets worse and worse and worse. What would happen if you sell bankruptcy sales? I sell bankruptcy sales.
And that's 50% of my business.
All right, if I go, Your Honor, and I'm gonna sell that farm, the bankruptcy court has approved that to sell free and clear. They've approved an absolute auction. But if that thing was to bomb out, and they came back and presented to the court, and that bankruptcy judge says, no, you're not gonna sell it, there wouldn't be nothing I could do about it, you could
Yeah,
do
but
about
see,
it.
that's why I will never use the word absolute on a bankruptcy
I don't
sale.
either, I just advertise.
Because
Well,
I use court orders.
Howard made the comment a while ago that absolute was the most powerful word in advertising, and I almost said it at the time. I'll go ahead and say it now. Bankruptcy's right there with it.
Yeah.
I mean, you advertise a bankruptcy auction, it's just as good because people are under the impression that you're going to sell it. Most of the time, you are, but there's always a chance something.
My opinion is you shouldn't advertise a bankruptcy auction absolutely because of what you just said.
Well, they want it done this way. There's another entity involved that owns part of this corporation. They want it absolute. Bankruptcy court approved it absolute. It don't make any difference if that judge.
Yeah, that's right. But like you said, if it bombs and it does, and they don't approve it, it ain't sold. You still got a contingency in that deal. That's why I never feel comfortable putting absolute on a court order sale, period.
Oh, I used to use it all the time. I mean, court order selling absolute subject to court approval. I don't personally see anything wrong with that. That means
I still have an issue.
Well, I agree. I hear what you're saying, but I don't.
Now, something else too, the bearing the room on both of these ads right here were online only auctions.
I wanted to ask that question a while ago.
So do we have any authority at all
Do you?
if it's an online only auction?
Yes,
I guess if they have a license.
If they're a Tennessee license,
We have a license.
Right.
They were licensed.
Yeah, they're Tennessee
I
license.
don't believe if you got a Tennessee, if I go to I don't know about real estate. Does real estate have the same rule as what it is personal property?
That eBay law put online auctions under the same exemption as bankruptcies and court sales and charity auctions and everything.
Yeah, you don't. Yeah, you can sell if you're a broker in California and you want to have an auction in Tennessee, you don't have to have a license.
And if I'm not a broker,
It don't matter.
If it's a live
So I don't
simulcast,
think-
you do.
No,
Yes.
online only.
Not online, only.
Online only. If you have
Need
an
a
online
time
only,
bid?
Nope. Time bid.
time bid.
Yeah, they're saying timed, Donna.
Yeah.
Timed
It's
is.
it's a time bid online auction. As long as you're not having a live auction in conjunction with it, you're exempt.
well, but I don't believe just cause, was this a timed auction? I can't read
Well, it
that.
says online only, so I'm just assuming.
I mean, does that, I couldn't see it.
Yeah.
Yeah, with a second, flip over the second.
Yeah.
Oh, okay, that's a lot clearer.
And this one says it too. Okay.
Well, I don't believe we have any control over it, just
Yeah.
cause
The first one was online only also.
just cause he'd have an auctioneer's license, I don't believe he can do anything.
She was
to it.
bringing up the discussion about it. Absolute.
Yes,
She was
because
just
I-
using that as an example. There's nothing we can do about this guy. Because it's an online only auction.
Well, right, you're right. I brought this up just so we could get the discussion out there about absolute with conditions on it.
There's no such thing.
Because every seminar, every class I've been to with the National Auction School, there seems to be questions on this issue all the time. Can we do this? Why isn't something being done about it? So,
Just
I
go to the UCC and read it.
That's what I was just scribbled my right there.
Well, Should there be, I would like for Julie, while we're writing rules, to do something to clarify that, so I can point to, look, this is the commission's rule.
Whatever we gotta
definition,
write,
you
whatever we
have
gotta do, we have to enforce that aspect of the law.
We have a definition of an absolute auction. And I don't think there's any leeway in it. It says an auction that is sold without reserve and can only be withdrawn if no bid is accepted in
At a reasonable amount of time. Right.
then it's an absolute auction. And the word absolute means absolute.
I believe you could change it before you even call for a bid.
Yeah,
Yeah,
he
you
said
can.
that.
You can.
That's what I said.
You can, but you have to make that announcement.
And you don't need to do it every sale.
Well, I
It's just
think the rule, the law says if no bid is taken within a reasonable period of time, you can withdraw.
Right.
I don't know that you could just walk up there and say, hey, and I know 5 auctioneers around me that do it. But I don't think it's right. I don't think that you can advertise an absolute auction and you walk up there the day of the sale. So, ladies and gentlemen, this thing is almost absolute. I mean, it's just close to being absolute. But I just talked to the owners and they've just got cold feet on me about selling it absolute. But I assure you, this thing's going to sell now. Let's have an auction, and that is not right because they advertise it as an absolute auction.
It's absolutely a classic definition of bait and switch.
What would you like complaints open on these two? They're both
Okay.
online.
I think they're online only. I don't think there's anything.
We have no jurisdiction.
I'd like for somebody to check and
Not
see
even
if
over the
there's
advertising.
any jurisdiction over the advertising of it. I mean, just because it's an online auction, I don't believe that you can just advertise anything you want to online and somebody not hold your feet to the fire. And I don't know if it's the Auctioneer Commission or the Consumer Affairs or who it is, but somebody has jurisdiction over doing something that's false and misleading to the public.
I don't believe it's us.
We're gonna toe the line on this,
I
huh?
don't either.
Julie, I was just asking, while we're doing this rule change, if we need to make a stronger paragraph in there about it being an absolute auction, being an absolute auction.
And I think that might not hurt if that's the way y'all want it. If, when y'all are looking at it next month, would you all jot down some notes on maybe some ideas for that, and I can try to draft something on it, because I think it would be probably helpful. And I'll work on something as well. Just a pretty short statement basically stating if you utilize the word absolute in your advertisements, there can be no contingencies. Is that, am I understanding you all correctly, that that's what you want? That's your understanding of what the law is?
As far as I'm concerned.
Okay.
Yes, ma'am.
And I would appreciate if, when y'all are looking at it, if y'all could, make some notes. You may have some better ideas on how to state it more clearly than that, but I think that it wouldn't hurt to add that as a subsection to our advertising rule, just to make things clearer.
We just need to be careful.
I'd like to get
That's
some
all I
more
got.
teeth.
Yeah, you can open up a can of worms.
We just need to be careful.
Well, I think we've got the rule there, and it needs to stay like it is.
I think we need to enforce it. We just need to be careful.
You got a rule, you don't have a rule there that says there's an absolute auction.
The definition.
If you advertise falsely, then you
It's
fine.
in the statute, is what it is.
It has a definition. Do you have that?
The definition is found at 0160-01-.19. That is types of auctions defined. The following rule that ends in .20 is advertising guidelines. And subsection 3 deals the rules. It's 0160-01-.19 is types of auctions defined. The following rule are the advertising guidelines, and subsection 3 of that rule deals with mixed auctions, auctions where some things are sold with reserve and some things are sold without reserve.
This auction should have been advertised absolute with reserve. or just with reserve?
Auction should have been advertised as an auction, period, auction.
Real estate auction, online auction.
No using no words, not absolute or with reserve, because it's telling you it's with reserve when it says it's subject to the payoff.
Well, you could almost amend that 20.2.e. Says advertise any auction using such descriptive words as urgent, emergency, distress, or any other word that connotes a liquidation that the buyer's will for its be in position to keep. I think if you advertise absolute.
We could just add another subsection.
Yeah, I
Advertises
do.
any auction using the descriptive word absolute.
Yeah, I would do it like paragraph H right there.
Maybe absolute with contingencies.
Yeah, absolute cannot have it. If you advertise absolute, there may be no contingencies upon the condition of absolute.
Well, I think that's what it says right now.
Yeah, but it doesn't call under the false, deceptive, misleading, or untruthful advertising. But it is false advertising.
I think if somebody complains about it, it's up to us to decide whether it's false advertising or not.
Somebody's been doing a lot of talking about it, because I've had 2 or 3 people saying that we was fixing to try to change this.
Well, somebody said something to me here recently, and I said, well, it's the first I've heard of it until
This
today.
This is the first I've heard of it.
Me too.
So somebody got better connections than I do.
Well, the person that sent me this and talked to you on the phone will be watching video. They're going to watch and see
Hello.
the discussion. So we're decided then to maybe tighten it up a little bit in the rules.
We're going to decide if we're going to talk about it.
We'll work it into the discussion
Yeah.
next month to see if we want to pursue that. and get
I'll
into
go
it.
back on what I told Susan a while ago. If that guy that advertised that is a Tennessee auctioneer,
Well, I mean, that's gray area too, because I don't know if he's a licensed auctioneer doing online. I don't know, online timed auction. We might have some authority over him.
well, you do.
If he's got a license.
You need to decide that, because I'm probably fixing to start doing some of that, and I don't want my license coming under that. I'm just going to tell you. If these other folks can go out here and
Well,
don't know anything
Been
about
thinking about the same thing, Mark.
if they don't go out here, and I'm going to set me up, if I don't change my mind, a different company.
To do online only.
Do online only, and I don't want anybody saying anything about it. Period. About how I advertise or anything else, because it's done past. We got beat in the legislature, and that's law.
I don't know
These
what- I don't
folks
know
selling
what-
all these foreclosed houses are not auctioneers.
I know they are.
So then it's not gonna
anybody-
change. So why do we wanna sit up here and put a hardship on
I agree 100%.
our auctioneers, say, oh, we're gonna make you
Well, I say be
but you
penalized
got
for being licensed.
Yeah, I'm not
I
for
agree.
that.
But I don't think you have to change it, get you another company. I think you can do it under Alexander.
I think I can too, but I think
Because
we
it-
can.
You just don't take it, can you?
But I don't, us to
Somebody
sit up here
second
and somebody say,
Los
well,
Angeles, California can auction out that building off of our online and never, don't even know what a Tennessee auctioneer license is.
so why do we wanna keep putting in laws that covers our auctioneers?
Is there no chance of getting that remedy?
I don't know how you could.
We fought with the, what do you call these people that get paid to,
The lobby.
lobbyists. We fought with the lobbyist, and he came, and he's a nice guy, and he came and sat here and whipped us big time when he took it to the legislature, and they voted it unanimously. And so now there's nothing we can do about it.
Well, the sad part about the whole thing is the drop-off stores and stuff like that, we were wanting to license in the first place. Left in business.
They really are.
No, there's not. There's no left in business.
In fact, eBay's really out of the auction.
Yeah, about all it's got big stores on the end.
But I don't think we have any control over online only auctions, but I think we have control over absolute auctions. I think we don't need to mess with it.
Well, I'd like for us to think some more about like what Marvin said, or Jeff was talking about, you got a licensed auctioneer. who's doing online only. I mean, I'm like Marvin, he should be penalized for having our license.
For having what?
Except that a licensed auctioneer is supposed to be cognizant of the law and the ethics that he must.
That's what I'm gonna advertise.
The laws
I
are-
want to. I am cognizant of it. You don't have to have it.
Yeah, but you know you just can't advertise it absolutely, it has a mortgage on it.
Oh, yeah, we're talking about
You're talking about
two
legitimately.
different subjects.
Yeah, I'm talking about,
I think you could online.
I think that
I
this,
think you can online. Show me where you can do it online.
yeah, Marvin, it's still don't make it right.
You got a license, this firm was licensed.
I know it, but we don't control that part of it.
Where's
We
the,
control.
where's exemptions under it?
6219-103, and it's titled exemptions, but the way it's worded does make it somewhat open to interpretation, I believe. It says the provisions of this chapter do not apply to. It doesn't say you're exempted from licensure for, however, these are the items that exempt you from requiring a license. So it is a bit unclear as to exactly, if you fall under one of these exemptions, what you are exempted from.
What page is that?
I have a code
Page
book.
three, Mark, Mark.
I'm sorry.
It's page 4, so it's actually,
Yeah, page
very-
4.
this number 9 is the very end. It says, any fixed price or time listing that allow bidding on an internet website but that do not constitute a simulcast of a live auction. Any fixed price or time listing. So under that, under that one paragraph right there,
Do anything under exemptions.
it
The
says
Attorney
any.
General rule is if you have a time to start an auction online and a time to stop the auction online, the definition of it is not an auction. That was his rule when they got this passed.
Yeah, but then they'll not be able to advertise it as an auction.
Well, but they can.
Time period.
Under that,
We done been down that road. So we ain't
under
gonna
that
be
right
arguing
there,
about that no more.
any means any, and that includes any licensed auctioneer.
All right, so what are you saying?
But I still think if you have a Tennessee auctioneer license, that you are supposed to follow the rules and the law. And if it says that you can't advertise an absolute auction that has a reserve on it, you can't do it.
If Julie were to take you into court under that right there, she could get you off everything. But this says any.
And it says the provisions of this chapter do
Right.
not apply to.
Right.
I'm going to look at this a little more, and I'll talk to y'all. We can take it up with the discussion next month.
There's
because-
no use wasting your time. We've been beat on that. It's over. It's too much money involved. We weren't gonna win. We didn't have the money to fight that. The connections.
Can you, in good conscience, let a licensee go around advertising?
You can't do nothing about it.
Well,
I think you
The
can.
answer is no, but you can't do nothing about it.
what if he advertised for a livestock auction
It don't
that
matter.
was not?
If it's timed online.
Timed online only.
No, the livestock auctions are exempt, so what if he advertised
No,
improperly?
they're not exempt.
It just, they're under exemptions.
They're under exempt from a firm license. But you
Yeah.
still gotta use, it says in there, you have to use a licensed auctioneer.
But
But on a
if it,
time one, you wouldn't have to.
but still, if he did some sort of advertising violations in conjunction with that exemption, you, I think, could still discipline him something like that.
We have a man that stole thousands of dollars, 40-something cases against him, and this auctioneer commission can't do nothing about it. And that's been going on, what, for 2 to 3 years now?
Oh,
So why do we want to spend our time on penalizing one of our honest auctioneers when we can't do nothing about something? I mean, there's no use pursuing an avenue we can't fight. In timeline auctions, unless we get a new legislature, we can't fight it.
well, that guy you're talking about hasn't really been found guilty of stealing anything yet.
Most of
Even
them
though he
folks
stole
that said
everything
they
he
did.
got.
Not,
Even if this is an online auction that's exempted from the auctioneer commission, if you felt that it was, a deceptive advertisement, then it would fall under Consumer Protection Act and could be referred.
I'd go right back to that paragraph number 9. I said, any time event. Doesn't say by who, with who, it says any. Any is any. It's like Bill Clinton said, what does the word is.
And of all the different things that can be sold at auction that you can't sell, you can sell if it's a timed internet auction.
That's right.
You know,
Because they're a web service provider, they're not auction
vehicle, gun,
Well, all right.
whatever.
I'm gonna,
No, I don't like it.
Do we have-
I mean, if I thought there was anything we could do about it, I'd be all
we're
for
gonna
it.
get this in the minutes,
Well,
so just right, so that we can refer to these minutes and I'll have something to enforce.
I would like for someone with the proper authority to check it out to see if a licensed Tennessee auctioneer can advertise online an absolute auction that is valid misinformation.
I'll talk to
Yes,
her.
right.
I'll also discuss it with Mark and possibly speak about it with our Deputy General Counsel, but it's going to be an interpretation of that statute.
If
is
you
what
can
it's
do
gonna
this,
come
if
down
you
to.
can do this and get by with it, there's really not much need to have any laws or rules, because I could, like Marvin said, I could sit up there and do everything I'm doing online, as the bidding starts at 7 o'clock and it ends at whatever time you think you're going to get through, and you can do whatever you want to. And I
That's
don't
where we're headed anyway.
I don't think that's going to hold up. And if we need to go to legislative,
Yeah, but you're talking about now, you done changed the rules of the game. You'd be right underneath that, because you're talking about, you could get up there and auctioneer, and that's a simulcast auction. They're not exempt.
no, I said put it online.
Yeah.
But if you
Online
say-
only.
Online only.
It's gotta be online only.
But you got your people sitting out there, I mean, you know, they got computers, and they sit out there in your audience and bid online, and it'd be over.
But that's in conjunction with a live auction, though. Isn't it? What you're talking about?
You could have it at.
Oh, yeah, I see
Civic
what you're
Center
saying.
Online, and everybody comes over there, and they take the stuff when they go home, or live in real estate, whatever, you can do it. But this, I can't believe that this is not a violation of something.
Oh, I think it's deceptive and misleading. Just with it being online only, I don't know. I'd like somebody's opinion on that.
We'll touch back on this next month.
Okay.
So, or next meeting, I'm sorry, I guess it'll be 2 months.
Feb.
But still my questions, why would we want to spend our time to do that just to make it harder on the auctioneers in Tennessee to work? When anybody else can do it that doesn't have a license, do whatever they want to.
I think what you're saying is if it's a company that's unlicensed that only does online auctions, they could do this all day and be exempt because they're exempt from it. So why?
Why do we want to make somebody that's paying our dues where they can't compete
Well,
with somebody?
I think Howard's point was, if somebody's misleading advertising, it's misleading advertising, whether it's somebody licensed or not.
We can't do anything
I
about
think
it.
though, if they don't have a license because they do all online auctions, for example, if that's all they do, so they don't have a license, we can't discipline them under advertising because they don't have a license. And I
That's
think
what I'm saying. I mean, why
what
ask for-
Commissioner Alexander is saying is, if you have a license and you do the same thing, just because you do some live auctions, why hold them to standard
I
that?
agree.
So I see what you're saying, but I'll look into it
I can
because
get
the
on
way
both
this.
sides of that argument.
Yeah. Well, I think somebody.
Well,
grabbed my line.
can you
Right,
do
go
this,
ahead.
can y'all do this, can you take this to the Attorney General and get his opinion of misleading advertising online in the state of Tennessee?
I
Maybe
think
his
we're not
opinion
quite,
on
we
it.
might discuss that next month, but I thought more what y'all had a question about was, would an
If
exemption.
we're gonna do that, I would like to find out, let's not do it with somebody, I'd like to find it out with somebody that's not licensed.
Well, we have some jurisdiction over somebody.
Well, yeah, we don't have.
Yeah, but
There is a state
misleading
law
is
for
misleading.
deceptive and misleading advertising under the Consumer Protection Act.
Right.
If it's a non-licensed entity that doesn't meet the license requirements, then this body
And then we could refer it to
couldn't do
them.
anything to that,
Right.
that individual, but it could be referred to consumer affairs. If it's a licensed individual and they violated that, or they met your license requirements, then you can impose penalties.
I understand Marvin's point. I can't disagree with it too much. What else we got? Mr. Chair?
I'm done.
Do we hear a motion to adjourn? Anybody got anything? Second. All in favor?
Stand up.
I'll have to save you a phone.